I see that we're live, so good morning and welcome to this public meeting of the Health Coverage Insurance and Financial Services Committee. We will begin this morning with introductions of the committee, and then we'll go to a public hearing when our sponsor joins us. We're waiting for him to join. And following that, we'll take a break for a caucus for each of the parties to meet and discuss the bills we will be working following the caucus. So I will begin with Representative Quint.
Good morning, everyone. My name is Tracy Quint. I represent House District 144, and I have all my towns today. So Amity, Bancroft, Benedict, Cary, Glenwood, Haynesville, Hodgdon, Holton, Macwahock, Molunkus, Orient, Reed, Silver Ridge, South.
Oops. Okay, we missed the last couple towns, Representative Quint, because you cut out.
My internet at my friend's house isn't very stable up here. So the last few, I guess, Reed, Silver Ridge, South Aroostook, and Weston. Maybe?
Thank you. Thank you. Yes. Those are the ones we missed, I believe. Okay, Representative Arford.
Thank you, Madam Chair, and good morning, everybody. I am Representative Poppy Arford, and I represent District 49, the western part of Brunswick.
Representative Evans.
Thank you, Madam Chair. Good morning. I am Richard Evans, and I represent House District 120, including the towns of Atkinson, Brownville, Dover, Foxcroft, Medford, Milo, Hornerville Township, and Lakeview Plantation.
Representative Matheson.
Thank you, Madam Chair. My name is Christy Matheson, and I represent the huge town of Kittery.
Thank you. And Representative Blyer.
Thank you, Madam Chair. Good morning, everybody. My name is Mark Blyer. I represent District 22, which is all of Leamington and part of Standish, Limerick, and Buxton.
Thank you. And Representative Brooks.
Good morning. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
Representative Melorano.
Good morning. My name is Gina Melorano. I represent House District 62, and that's part of Auburn.
Thank you. And Representative Morris.
Good morning. I'm State Representative Joshua Morris. I represent House District 75, which is Turner, Leeds, and Livermore.
And Senator Senator Brenner. One of those senators.
What a compliment. Good morning. Thank you, Madam Chair. My name is Stacy Brenner. I represent Scarborough, Gorham, and Buxton, Senate District 30.
And I am Representative Denise Tepler. I'm the House co-chair of the committee. My other co-chair will be serving in judiciary today. And we are ably assisted in our efforts today by our OPLA analyst, Colleen McCarthy-Reed, and our committee clerk, Edna Caford. So that's all of us, and hopefully has Representative Martin joined us?
Unfortunately, I don't see him yet in the attendee space, but hopefully soon.
Okay, I think we'll give him about 5 more minutes. And if he isn't here by about 20 after, I think we'll ask someone else to stand in for him and read the bill title. So,
sure, we can.
So just so folks on the committee know, if you want to turn off your camera and take a brief break, I just turn up your volume so you can hear me when I call you back. And I apologize to both those folks in our attendee space and the folks who might be listening online, but we're waiting for the bill sponsor for our public hearing. Okay, committee, please come back. I see Representative Martin has joined us in the attendee space. So please come back and join us, and I will open a public hearing on LD 2004, an act to ensure fairness of representation in insurance disputes. And I will ask Representative Martin to come over and join us in the panel.
I brought him over, so I think he's here and he'll just need to unmute and turn on his mic, I think, and hopefully it will work.
Thank you. Representative Martin, if you can hear me, will you please turn on your camera and turn on your mic? Oh, there he is.
Good morning.
Good morning and welcome to HCIFS. Please present 2004.
Thank you, President Templer, members of the committee. I am John Martin, and I represent House District 151 in northwestern Aroostook County. This bill was put in at the request of a local citizen, basically concerned that when there's an accident that occurs and it's the same insurance company that covers both parties, that the insurance company basically uses the same attorney to settle the case. And the feeling was that if that should occur, the person should have an opportunity to have an attorney that is basically, not representing both parties at the same time. And that's really as simple as it is. Maybe that bill is not drafted to say that, but that's the best I could do with the drafts. And I understand that the department is concerned about that, and I fully agree. But there must be somewhere in this country where there's an opportunity for someone to complain if the insurance carrier happens to be covering both parties. And it's really that simple.
Thank you very much, Representative Martin. Any questions from the committee for the bill sponsor? Yes, Representative Melorano.
Thank you, Madam Chair. Thank you, Representative Martin, for being here. My question would be, did your constituent file any kind of complaint or anything with the Bureau of Insurance for what happened? And if so, what was the outcome? Thank you.
I'm told that they did, but was told that they had no authority.
Thank you.
All set, Representative Melorano? Thank you. I guess I don't have the power to lower your hand, so if you could, that would be helpful. Thank you. And Representative Martin, I have a quick question for you. To me, as the bill is drafted, it's a more broad brush than just situations where the same insurance company represents both the plaintiff and the defendant. So, if that was your intention, the bill may need to be modified to meet that intention.
Yeah, maybe the department could lay it out and come up with a scenario as to where if there is an appeal, they can act on it quickly. And then the constituent then would not feel as if they're being mishandled.
Thank you, Representative Martin. Any other questions for Representative Martin? Seeing none, we thank you for presenting the bill and will return you to our attendee space and ask if there is anyone in the attendee space who would like to speak in favor of the bill. Seeing none, I will turn to those who would like to speak in opposition to the bill. And first, I will call Adam Cody. Welcome, Mr. Cody. Please present your testimony.
Thank you. Good morning, Representative Tepler, distinguished members of the Joint Standing Committee on Health Coverage and Insurance and Financial Affairs. My name is Adam Cody, and I represent State Farm. I'm testifying today in opposition to LD 2004. State Farm, as many of you know, is the largest property and casualty insurer in the United States. State Farm is opposed to this bill primarily because it would dramatically change decades of property and casualty policy language that's already been approved by the Bureau of Insurance. And it would effectively upend casualty insurance policies throughout the state. As far as I'm aware, there isn't a state in the country that has policy requirements such as those envisioned in the bill. But let me depart for a second and explain, hearing Representative Martin state the reasons for why he presented the bill. There are essentially two ways that this issue that he was putting forward would be addressed or should be addressed. Neither of them would be required under this bill. The first is that all attorneys already have an ethical obligation to their clients. If they violate that obligation, they can be censured or disbarred by the Board of Overseers. That's where you would send a complaint if your attorney isn't representing you properly. So that's the first point. The second is the situation where two insurers, where you're representing two insurers, if there's a conflict of interest in representation, and if it does in fact exist, there's already a mechanism in place to address that. It's longstanding case law. It's called the HCIFS Council, and it's named after a famous case in California. Maine adopted this principle in 1980, and it essentially says that if a conflict exists for an attorney where they're representing essentially both sides, then the defendant can essentially demand to have outside counsel appointed. What this bill does is effectively upend that principle, for lack of a better term, and it would essentially, it kicks in sometimes where there's discrepancy over how much is covered under a claim. And if that happens, then the defendant can demand the insurance company pay attorney fees for an attorney that they select. So I'm not sure of the situation that gave rise to this, but that could have been an option here as well. This bill essentially applies the HCIFS Council for both situations, plaintiffs and defendants. And what it would end up doing is create a conflict of interest for insurance companies, because insurers are contractually obligated to provide a defense for their insured for a covered loss, and they're legally required to attempt to resolve that claim within the liability limits. But if you require insurance companies to also pay for plaintiff's fees, the conflict would arise with their legal and contractual obligations to settle a case. So you're essentially creating a conflict of interest for insurance companies rather than having them pursue it with a board of bar overseers or seek an outside counsel, which already exists. So for these reasons, I would encourage you to ought not to pass. I'd be happy to answer any questions you may have and appreciate the opportunity to speak to you today.
Representative Tepler, you are muted.
Madam
You're
Chair.
muted.
Thank you,
Yeah.
got it. Sorry. Representative Evans, do you have a question for Mr. Cody?
Yes, thank you, Madam Chair. Mr. Cody, just in your experience, how often have you seen situations develop like this that the bill is addressing?
It's kind of rare, frankly, sir, to see the HCIFS Council doctrine kick in, primarily because it ends up a lot of times leading into further litigation and fights. But that's why it's been established as sort of a safe check if a conflict of interest applies. I will tell you that as an attorney, we are required to attend continuing legal education requirements every year. And we are required to get training every single year that we are in practice on conflicts of interest. It's one of the biggest things that you have to look out for as an attorney. And it gets dicey when you're representing both sides. You have to get what's, in cases where you can do it ethically, you have to get informed consent from both of the sides saying, you know, I'm effectively, you know, acting as attorney for both of you. And there's certain, without, you know, getting into all the different times that you can and can't do it, I will say it's only done when both both sides to this agree to do it. So a mechanism in place, and it essentially, the onus of complying with it falls on the attorneys, as it should. And this essentially sort of flips that. And I'll also say in insurance practice in these types of things, I mean, there are, you know, limited number of attorneys who are sort of good and focus on this type of thing. I'm not a plaintiff's counsel, but I would think a lot of plaintiff's counsels would also have a problem with this bill. A lot of times, as you're aware, they structure their fee arrangements set upon contingency fee basis, which essentially says if I win, I get paid. You know, this type of situation where you're requiring an insurance company that's also defending the other side to pay that bill, I can't think of how many problems that would create, but it would completely upend how our system works now. Hope that answers your question.
Thank you.
You all set, Representative Evans? Thank you. And Mr. Cody, I have a quick question for you. Does the case law, the humus doctrine, have the force of a statute?
Well, it does until a statute is created that disagrees with it. You know, your role is to make laws, right? So, you know, if you changed it, you could effectively change the case law practice by writing a law that essentially goes contrary to that. So I don't think you have a constitutional requirement, a constitutional issue here. I'm not a constitutional lawyer, so I'll caution by saying that. But I'd simply saying the point that there is case law in existence to deal with situations such as this now. And that's how it's. Yes, ma'am.
Thank you. Seeing no further questions from the committee, thank you for your testimony, and we'll return you through the wormhole to the attendee space. And next I will call Mr. Yardley of the Bureau of Insurance. Good morning, Mr. Yardley. I'm sorry, I actually should have called you first. I was just
that's
going
quite
in
all right.
order of the time of registration that I have.
That's quite all right. I'm happy to have followed Mr. Cody. But please bear with me for a moment. I'm in the office today and the setup isn't quite what I'm used to. Good morning, Representative Tepler and honorable members of the committee. My name is Ben Yardley. I'm senior attorney at the Bureau of Insurance. I'm here to testify in opposition to this bill. You have my testimony. I think Mr. Cody has covered a lot of the practical issues that attorneys face. While complaints are confidential and I'm not personally familiar with the complaint that Representative Martin mentioned, I would encourage him to reach out to us and we'll certainly take a look at what happened. I just can't speak to that. We do have concerns about what the bill is, as written, is trying to do. I would point out that the insurers have a well-established obligation to defend and to control defense and settlement of cases. I don't know if that's what this is about. I just want to point out that there are some protections already. If there's a question of coverage and the policyholder or insured brings a declaratory judgment action against the insurer and prevails, the insurance code provides for the payment of attorney's fees to the prevailing policyholder. And there's also a first party claims act, section 2436A, which gives insurers rights against their insurers. I would, as long as I have a public platform at the moment, I would encourage anybody who has a complaint about an insurer to contact the Bureau of Insurance. This is an essential part of our mission. I would just say also that the bill doesn't set standards that ensure the competence of the insured's attorney or how much the charges for the attorney's work would be. I think Mr. Cody pointed out that insurers are responsible for their insured's defense costs, not for the costs of, except in very limited circumstances, of the parties who sue them. I did a quick look through the established legal source Google and did not find any similar bills or laws in the country. So I think this would make Maine an outlier and could have adverse effects on our highly competitive property and casualty markets. So with that, I would thank the committee for listening to me, and I will be glad to try to answer any questions now or bring information to the work session that the committee desires.
Thank you, Mr. Yardley. Are there any questions from the committee for Mr. Yardley? I have a brief one. So from the information that Mr. Cody gave us, it's my understanding that there's case law around conflict of interest. And in fact, I believe, having looked and done a Google search myself, that there is case law in all states or in most states around the issue of attorney's conflict of interest. Is that the business of the Bureau of Insurance, or is that the business of the overseers of the bar?
Yes, and that's an issue exactly that I was thinking about while Representative Martin and Mr. Cody were testifying. The conversation in my mind started to drift more towards what the ethical obligations of attorneys are. We don't deal with that. We deal with insurance regulation. And I would say that in the first party context, there is well-established law, case law, that insurers have an obligation of good faith and fair dealing with their insureds. And that's in addition to the protections that I mentioned a moment ago that are statutory. Does that answer your question, Representative?
Yes, it does. Thank you, Mr. Yardley. Okay, so in that case, I guess the only other piece to that would be, should Representative Martin's constituent be speaking to you, or should they be speaking to the overseers of the bar?
Well, I guess the question, or the answer might be yes to both, because I still don't understand what happened. I don't know if it's there. Maybe it's just that I didn't hear what Representative Martin said. I had understood this was about what an insurer had done, not what an attorney had done. But I could be wrong about that. If it's about what an attorney did, then I think the constituent should go to the overseers of the bar, who have processes to deal with this, as Mr. Cody outlined. If it's something that the insurer did, then by all means, they should come to us.
Thank you, Mr. Yardley. Oh, and I see that Representative Brooks has a question as well. Go ahead, Representative Brooks.
I had a question for either now or at the work session. I understand that there are processes in place to help eliminate conflicts of interest, but it seems, especially in a rural state where there may not be as many people in the insurance market, that it's easy to see how, if not an actual conflict of interest, there would be a perceived conflict of interest if it was one attorney, one insurance company representing both parties. So even if it's a perceived conflict of interest, I'm a little bit hoping that there could be more clarity. Are there any suggestions that the Bureau would have as far as maybe making it so that the person that has an accident, unfortunately, feels empowered to reach out to the Bureau of Insurance, empowered to reach out to the insurance company or the overseers of the bar? I guess that's where I'm kind of looking towards, if you have any suggestions.
Thank you, Representative Brooks. So I think there are already plenty of guidelines and processes in place. The Board of Bar Overseers has a website. The Maine State Bar Association has a website that I think directs or educates the public about their rights with respect to hiring attorneys. The Bureau of Insurance has lots of information and gives very high publicity to, or makes it very easy for anyone who thinks he or she's adversely affected by the action of an insurer to file a complaint. And I think it would probably be helpful to hear from some of the speakers who were lined up after me to ask them about what processes insurers have to deal with what I understand is this pretty rare circumstance of having a policy on parties who might be adverse to each other. My experience with insurance litigation has been diluted by approximately 35 years of doing other things. So I'm not the expert in that, but I understand that there are processes for separating investigations and having different adjusters, and I would assume different lawyers.
Thank you.
Thank you, Mr. Yardley. Seeing no further questions, we'll return you to the attendee space and hope you'll be present for our work session. Thank you. And next I will call Mr. Sultan. Speaking in opposition to the bill.
Thank you, Representative Tepler and members of the committee. My name is Charlie Sultan. I am an attorney here in Augusta and am representing the Maine Association of Insurance Companies, which are your Maine-based domestic property and casualty carriers. The conversation today has gotten way off the bill because the bill is so poorly drafted and doesn't address an issue that is really out there. You would have had, if there was an issue, you would have had proponents from the other side of the trial bar here talking quite extensively about it. Let me get you back to sort of grounded to what we think the bill is actually addressing, or the complaint that was filed, or not a complaint. It wasn't, I mean, this all generated by an email from a lawyer up north that is actually not a constituent of Representative Martin's, but up there. Theoretically, we believe that the situation was that there were two people involved in an accident that were insured by the same company. They would not, the insurance company would have very different roles in this. So for the plaintiff, they would likely not have any dealings with because the plaintiff is suing the defendant who is alleged to have caused the fall, been at fault and caused the injury. You buy an insurance policy, your homeowner's, your auto policy, to defend your financial interest. And that is absolutely key. You can go without insurance, not auto insurance, but you could not insure your home and take the risk of losing the value of your home and your investment in it if it goes up in flames. But you make a financial decision to insure it so that you do not have, you have a much smaller investment in insuring that financial risk because you and everybody else in your community is insuring that product so we can, buy that product for a much lower amount. We as the carriers then have a duty to defend you if you are you have caused injury to others, created a liability against yourself. And so we step in to defend you, and we do that zealously because that is our duty to you as the insured. If you're the plaintiff, you are going after the defendant and not relying on your own insurance coverage other than perhaps some first party property issues and things like that. Not until you get through your case against the defendant to determine whether or not, A, that they're liable, and two, whether or not they have appropriate coverage, would you then go back to your insurance coverage, your own carrier, for perhaps your uninsured motorist coverage if you have that on your policy, which you do. So this situation here is really not a situation that causes problems because the plaintiff is going to hire their own attorney. They're going to go to a plaintiff's attorney who to represent them in trying to get the at-fault party to pay damages. The person who's being sued by that plaintiff is then going to look to their insurance company to provide their own attorney for their protection and so on. So it's very difficult to understand the scenario. What we got off base here was when an attorney represents two different parties in litigation. That is a massive no-no and should never happen, period. You do not need a statute to do anything about that. It's like trying to represent both parties in a divorce. No, you cannot do it. Even with consent, it should never happen. So you're not going to represent in an auto case two people in an accident who have hit each other. That is a giant no-no. The insurance company would not allow that either because their responsibility is to defend the one party likely at fault. So we just need to take that whole scenario off the table, if you will. But the bill is before you is really affecting the two parts of P&C coverage, your property and your casualty. Casualty insurance is protecting you in your liability from losses that you may have incurred. Your property coverage, the half of your homeowners, for example, your auto, is protecting your own property. And so you need to separate how the insurance company looks at that. So we then use terms like third party and then first party coverage. Your first party is your insurer defending you and your policy that you bought to protect yourself. The third party is that person coming in trying to claim that you are negligent or at fault for some kind of injury, personal or property. And so that's the distinction. So the so-called scenario that this attorney has raised it would almost never appear unless the attorney, it wouldn't arise until there's a second stage to the case. So if you haven't gotten, it's when the plaintiff has exhausted his or her rights against the defendant, would they then look back to their own carrier? So that's a different case, a different issue. And so you're going to have your own attorney. But as Mr. Yardley talked about, we have a duty of acting in good faith for that kind of situation. It is highly set in both statute and in case law of our duty of good faith. And so we know as carriers how to operate appropriately to protect our insured in that case, who was asking for certain relief against us. So we hope that you kill this bill. It has not caused an outcry. They are not an issue. And we hope you can go right into work session and do so. So I'll end there.
Thank you, Mr. Sultan. Representative Morris, you have a question?
Yes.
Mr. Sultan?
Yes. Yep. Thank you, Madam Chair. Thank you for being here. So as I understand it, the way that this is written and the concern is if two people are insured by the same company and one person wants to sue the other, this would require the insurance company to cover the legal fees for the person who is the plaintiff versus you're always required to cover for a defense. That's kind of what, as I'm reading the drafting of it, how, and that's obviously a concern.
We would then be, in essence, violating our duty to the person who bought their insurance policy, because our duty is to you as the insured. And if you were to do otherwise, it would violate that duty and water it down, which would be detrimental to all Mainers who seek insurance coverage. And as many of you know, if you are a plaintiff and decide to sue someone else and an attorney takes your case, you sign a contingency agreement. And that contingency agreement provides for attorney fees out of the recovery of those damages that you recover. And so plaintiff attorneys are well compensated. There is a established system, and it works very well in every state in the country. And this provision, which is why we were all scratching our heads trying to figure it out when it came out, because the system works really well.
Thank you.
Mr. Sultan, just for clarity for the committee, could you explain why even in a settlement situation with the plaintiff and the defendant being insured by the same company, this currently works?
Because the plaintiff's attorney is representing their interest and pushing as hard as he or she can for a settlement that is advantageous to the plaintiff. The defendant's attorney and the carrier behind that defendant is doing their best to protect their defendant, their insured. And so there is that arm's length negotiation that works. They're not being represented by the same attorney. So remember, the duty in the situation where it is on behalf of the defendant, the duty on the carrier side is to the defendant and not to the plaintiff, who is represented by independent counsel.
And the attorneys on either side reach an agreement that binds the insurance company, and it's not the insurance company itself that reaches the agreement.
That's true.
Thank you. All right, so thank you, Mr. Sultan, for your testimony. Seeing no further questions, I will next turn to Mr. Bernier. Welcome, Mr. Bernier. Please go ahead.
Good morning. My name is Dan Bernier. I represent the Maine Insurance Agents Association in opposition to this bill. As your insurer has a duty to defend you, they do not have a duty to sue on your behalf. And I think the easiest way to understand this is with an example. Let's say there's a 3-car accident with myself, Representative Morris, and Representative Tepler. We all have the exact same insurance company. I sue Representative Morris and Representative Tepler saying they caused me injuries. That insurer, even though it insures all of us, has a contractual duty to defend Representative Morris and Representative Tepler. They have no contractual duty to pay my legal fees in suing them. Now, if the insurance company went to a lawyer and said, well, we want one lawyer to represent both Representative Tepler and Representative Morris, it's up to that lawyer to say that's unethical. That's a violation, and that lawyer could easily get in trouble with the Board of Bar Overseers. And most insurers know this, so they would never ask that. It's up to the lawyer to say, no, it's a conflict of interest for me to represent both of them, because it may be Representative Morris really did cause the accident and Representative Tepler didn't. So, or vice versa. Or we can flip it, yeah. But so there's an inherent conflict of interest in representing both of them. There are scenarios outside of personal injury where you can have simultaneous representation, but they're more in land use law, areas like that. I cannot envision a scenario where it would ever be ethical for a lawyer to represent both of them in that scenario. The other thing is the Board of Bar Overseers has been very clear. The client for the lawyer would be Representative Morris and Representative Tepler in those situations. It is not the insurance company. The insurance company just pays the bills. The lawyer's ethical duties are to the insured, not to the insurer. I first started practicing in the early 90s. I was an associate for a guy who did a lot of insurance defense work. And he actually had a letter he'd bang out right at the beginning of the case, a form letter, making sure everybody knew who his client was. And generally, even with the stuff I do now, you always want to make sure everybody knows who your client is, because that controls your ethical duties as a lawyer. The last thing I'd also point out, with the insurance companies, with these lawyers, they often do, because they can deliver volume, negotiate rates very heavily with the lawyers who do defense work, which saves us all money on our insurance rates. So that they do choose lawyers, and they have a list of them they will go to, is helpful because they're in a very strong position to negotiate very good rates with these lawyers. And then the second thing is, particularly in personal injury, the lawyers who tend to be good at it tend to actually be lawyers who know their medical jargon and can read medical reports. So you don't really want to just be choosing somebody off the street who's not going to understand medical reports in a personal injury case. So this is an area where there is some expertise to be good at this insurance defense work. I think I've covered everything I need to cover. I'm already up to about your 4th speaker, so I'll try to leave it there unless I'd be happy to answer any questions.
Thank you, Mr. Bernier. I see no raised hands in the committees, so thanks for your testimony. And we will next call Mr. Mahalik.
Good morning, Madam Chair and members of the committee. My name is Matthew Mahalik. I'm a attorney at Norman Hansen in Detroit, where I'm a partner and have been practicing in the insurance defense industry and handling insurance coverage matters for the past 15 years. I'm here today on behalf of myself as a consumer of insurance, and also professionally, given my line of work. In viewing this proposed legislation, I see a number of problems with it that have been already addressed by the individuals speaking in opposition before me. And I have addressed a number of those issues in my written testimony that I submitted. But I would like to highlight the fact that what we're talking about here are liability policies. We're talking about auto liability policies. We're talking about homeowners liability policies. And the way that the proposed legislation is drafted, we're also talking about commercial general liability and business owners policies. The far-reaching effects of this proposed legislation would touch on all of those, and what those policies have been geared towards, designed for, priced for, is defending insureds who the insurer has a duty of good faith and fair dealing with. It is not, those products are not designed for the prosecution of claims on behalf of their insureds that has already been identified. Those individuals have the availability to seek plaintiff's counsel that will represent them for a contingency fee, which is no cost to them. Allowing or forcing insurers to provide this additional service to insureds, where insurers are required to prosecute claims, is going to at least double premiums, if not more so. As I touched upon in my written testimony, we have problems in the state with individuals who cannot meet their financial obligations on a daily basis and would not purchase insurance unless it was required for them to do so in the context of automobile insurance. We're in the winter months right now, and we see all sorts of heating fundraisers to allow individuals to be provided assistance to pay for their oil bills. And now all of a sudden we want to contemplate enacting legislation that's going to double individuals' insurance premiums for something that they don't even need, given the fact that this was an isolated event where, by all appearances, the plaintiff's attorney that generated the bill or requested the bill was upset because the insurer was aggressively defending its own insured, which is what we pay the premium for them to do. I want my insurer to aggressively defend me. I'm sure all of you want your insurer to aggressively defend you if you were ever to be sued by a plaintiff. There are numerous cases where liability may not be at issue, but there's a huge dispute over damages at play. Not allowing an insurer to aggressively defend their own insured to make sure that the payment that is made on the claim is an accurate representation of what the true damages are will just cause a disastrous effect on the insurance industry and the premiums that we all pay. The only other thing that I would like to say here is that the language of the proposed legislation is ambiguous. And having practiced in insurance coverage matters and insurance defense matters for 15 years, the vast majority of my time is occupied by litigating what is the meaning of statutes, what is the true meaning of a judicial holding, what is the meaning of a contract. We will spend years trying to figure out what this proposed legislation actually means. There's no definition of dispute. There's no indication if this is only to apply in third-party liability context, or if it's supposed to extend as well to first-party context. So the legislation is unneeded, it's ambiguous, and it's going to result in an excessive amount of premiums being forced upon the citizens of Maine, who are, for the most part, unable to meet those additional burdens. I thank you for your consideration and your time this morning. And if anybody has any questions, I'll do my best to answer them.
Thank you, Mr. Mihalik. Any questions from the committee for Mr. Mihalik? Seeing none, we appreciate your testimony. And we will next turn to Mr. Whelan.
Good morning, Madam Chair, honorable members of the committee. Thank you for this opportunity. I am Rory Whalen, the Regional Vice President for the National Association of Mutual Insurance Companies. I'll be brief because I think the opposition and questions about this legislation have been articulated very well by the previous speakers. I think in terms of our collective head scratching this morning about the genesis of this, I would think that there is a problem with the fact pattern. There was an inference that in this case, this example, that the insurance company for the plaintiff hired that plaintiff's lawyer. That doesn't happen, and I think that was made clear this morning. So I think there might have been something lost in translation from that lawyer who sent the information of the sponsor, because that simply wouldn't happen. I think there are remedies in the rare instance of a conflict. There are remedies that lawyers, obviously, according to the bar and the canon, work out, as well as insurers. It is rare, but there are ways to work it out. Meaning, if an insurer uses a defense firm, they would not use the same defense firm for both sides. And these happen when there's a cross claim, right? So there's a suit and a countersuit, but in that case, it wouldn't even be the same law firm. If the insurer used in-house counsel, they would use that perhaps to defend and then hire outside counsel for the other claim. But again, it's very rare. And I would just lastly say, we're very familiar with the old adage, hard cases make bad law. There's also an adage that says that bad law makes hard cases. And in this case, I would say this law would make impossible cases, truly impossible to figure out how to enact. It sort of leads to more head scratching for me.
Thank you, Mr. Whelan. Any questions from the committee for Mr. Whelan? Yes, Representative Brooks.
Hi, Mr. Whalen. I had a question. What brings to light is just maybe an instance where perhaps somebody involved in a property casualty incident may not bring a claim because they can't afford representation. I guess that's a question that and that might not be as directly related to this bill, but I guess that's what I'm curious about is what if somebody doesn't seek out an attorney or doesn't get representation because they think, well, I can't afford one, or it's just too overwhelming.
So I would say, and I can't say I know this stat for sure, but I would say 99% of these cases, it is a contingency fee lawyer. So you would, as a potential plaintiff, you could interview at 1-800-LAWYER or any of the other commercials you see on TV. It's a free consultation. You only pay if you win, right? So there's no potential loss for the plaintiff. That's how these cases are adjudicated for the plaintiff. So, by the time you go to that third, fourth firm, contingency firm that says, we're not going to take this case, that probably means you don't have a good case. And if you had the funds to hire an attorney yourself, you'd be most likely wasting that money. Meaning, even those who are well equipped to pay for an attorney in plaintiff cases, they don't. They go to a contingency fee structure.
All set, Representative Brooks? Okay, thank you. Thank you, Mr. Whelan. Thank you for your testimony. I don't see any other questions from the committee, so I will call Bruce Garrity to the committee to testify. Good morning, Mr. Garrity.
Good morning, Representative. Thank you for the opportunity to speak on this bill. Representative Tepler and members of the committee, my name is Bruce Garrity. I'm here today on behalf of APCIA, the American Property Casualty Insurance Association, and AIG companies, which are insurance companies which provide protection in these kinds of cases. I don't want to repeat everything that other people have said. I think the arguments have been effectively laid out, but I would like to make a couple of points. Insurers have an obligation to an insured, but insureds have obligations to insurers. There is an obligation for the insured to assist in the defense of the case. The insured can't sit there and say, go do your thing, I don't care. And to the extent in this limited circumstance that an insured was to choose and go get an attorney who doesn't have the skill and expertise to handle matters involving liability, that insured risks breaching the policy by not acting appropriately. And I'll tell you how that could happen. Let's assume it's a medical malpractice case, or it's a case involving an engineering-based dispute, such as a product defect suit, or it's a case involving an accident, but you need accident reconstructionists and you need experts, and you've got to know where to go for the expert and how to build your case in defense of an accident reconstruction. If someone goes to their own attorney that they have used for wills and personal affairs, or they go to a estate attorney, or they go to a tax attorney, they're not choosing an individual who will have the skills to appropriately defend the matter. And I think that creates real problems under the policy apart from everything else. I would say also, again, briefly, this bill would cover commercial policies as well as personal policies. And because part of the bill deals with property versus casualty. To that extent, you would have businesses that are suing each other that are both capable of defending themselves, making good decisions, hiring appropriate counsel, or having the insurer hire appropriate counsel in a commercial case suddenly have to be defended and handled on both sides by the same insurer. I would also say that you're asking for real trouble with this in the sense of, if someone goes to a skilled plaintiff's attorney, they're going to, in all likelihood, be paid by a contingent fee. Well, if they're also asking to be paid by the insurer, what happens to the contingent fee? Is there a double recovery? Does the plaintiff's lawyer have to give up the contingent fee after the plaintiff's lawyer carefully evaluated the case, made decisions on how to handle it, and would know, presumably have a great deal of expertise? And I know a number of people in the plaintiff's bar who have those skills. Right now, we have what Superintendent Chapa calls the trifecta. We have the lowest basic auto rates in the country. We have the lowest uninsured percentage in the country. About only 4% of people in Maine don't have auto insurance. And we have the highest minimum limits in the country. So we've protected people three different ways. To the extent that premiums go up and go up meaningfully, you're going to lose that trifecta. And I don't see that as being in the public interest at all, because this committee's worked very hard over the years to make sure that people have as much protection as they can get. And the last point I would make that I don't think has been made is that these insurance policies need to cover in the event of a liability occurrence, not in the event of a claim that's made in equity. And I'm very concerned that this could broaden the scope of obligation to handle claims in equity as well. And I will give you an example. Insurers have to defend when there is a claim for damages of some sort. A suit in equity might not claim damages, but for example, someone might go to the DEP and say, I'm frustrated that this person over here has put in a dock where they shouldn't, and I want you to get them to stop. Well, an insurer doesn't have a duty to defend anybody in that case because it has nothing to do with liability and it has nothing to do with damages. This bill is worded so broadly that you could see obligations arise there, and that's just going to increase costs for everybody, go outside the scope of any policy that I'm aware of on the liability front, and we think that would create problems in terms of good public policy as well. So with that, Representative Tepler, I'd be happy to try and answer any questions the committee might have.
Thank you, Mr. Garrity. Any questions from the committee for Mr. Garrity? Seeing none, we appreciate your testimony. Mr. Garrity was the last person I had on my list who wished to testify in opposition to the bill. Is there anyone else who wishes to testify in opposition to the bill who's in our meeting today? Seeing none, is there anyone who wishes to testify neither for nor against LD 2004? Again, seeing no little hands go up, I will close the public hearing on LD 2004. Our work session on this bill will, I think, be sometime next week. Do we have a date yet, Ms. McCarthy-Reed?
Tentatively, I believe it'll be Tuesday.
Okay, so we'll have a work session on this bill on Tuesday. And all those who are interested are welcome to attend. And at this point, the committee will take a break. It is 11:12, and we should be back on right about noon. Well, actually, I think I'll make it 12:15, so if people want to grab lunch as well, we can do that. So let's get back on at 12:15 to do our work sessions for the day. So we'll all recommence here at 12:15.
Did we say 12:15?
Yes. we did.
Okay, just double checking that I'm in the right place at the right time. Thank you.
Good afternoon. I hope that our committee members are coming back into the panel. Welcome, Senator Stewart. We'll give you a minute to introduce yourself after we have a quorum here. Oh, we have a quorum now. All right. Representative Morris, I just want to make sure you're there. Are you there? Representative Morris? Well, I think we'll go ahead and proceed to work session. And I'm sure Representative Morris will be with us soon. So Senator Stewart has rejoined the panel. Please go ahead and introduce yourself, Senator Stewart.
Sure. Thank you very much, Madam Chair. Good to see you all this afternoon. My name is Trey Stewart. I represent District 2 in the Senate, which is 51 communities in Aroostook and Penobscot counties, and I reside in Presque Isle. And I also serve on the Energy, Utilities, and Technology Committee, where I was for the morning session, working on some bills over there, including one that I had. So apologize for not being able to join you folks this morning.
You're a busy man, sir. Okay, I just want to announce that Health Coverage Insurance and Financial Services is doing a series of work sessions this afternoon, and we'll be taking the bills up in the following order: LD 1331, then LD 1628, then LD 1910, and then LD 1822. And that's slightly different than the published order, but to accommodate some members of the committee, we're going to do that. Okay, so what I will do now is I'll ask Ms. McCarthy-Reed to bring the Bureau of Insurance in, because they're going to present some slides to us with some information on LD 1331 that I believe we requested when we heard this bill and worked it the first time.
Yes, you might recall that LD 1331 proposed to make some changes to the geographic rating factors for individual and group health insurance. And last spring, the Bureau told the committee that they were in the process of applying for some grant funding to help with an updated analysis of geographic rating. And part of that analysis has been completed. And so the Bureau has some slides to present to the committee. And I believe Ms. Hooper is going to introduce the consultants that worked for the Bureau in helping to prepare this analysis. So I'll turn it over to Ms. Hooper, and then when it gets ready for the slides, I'll pull them up and folks can just indicate to me as we work through them. I'll move through the slide presentation for you. That makes sense.
Thank you, Ms. McCarthy-Reed. And go ahead, Ms. Hooper.
Thank you, Representative Tepler and members of the committee. I'm Marty Hooper, the Life and Health Actuary for the Bureau of Insurance, and we have a presentation of some preliminary analysis of a project we've been working on to analyze the geographic factors that are being used for the Affordable Care Act plans, individual and small group. And I just wanted to give some background. As Colleen mentioned, we became aware of some federal grant money in December of 2020, expected that to be awarded in April. There was a delay, so I started the project with state funds in September, and we were aware that this bill had been carried over. So we're hoping to give some information on possible premium impacts for different changes in restrictions to geographic factors if that were to pass. So we did receive some federal grant money in October, so we're able to continue evaluating geographic factors. We have about another, a little over a year still left for that project. So we are anticipating to continue to study this, and this analysis and the results will help us greatly in our rate review, because that is part of the rate review to analyze the geographic factors that are filed with us. So I'm just looking at my notes to see if there's anything else I wanted to cover. I have here to present our consulting actuaries from Wakely, Jacqueline Young and Lydia Tolman. So I'll turn that over to them. And I think Colleen has the slides.
Welcome, Ms. Young, Ms. Tolman, and please work with Ms. McCarthy-Reed to put the slides up as you wish them presented.
All right, Ms. McCarthy-Reed, if you just want to share, we'll get started. All right, so as Marty mentioned, we've been looking at an analysis of the existing rating areas, the geographic areas, and then kind of looking at potential other options that are related to this legislation you're considering. So if you'll move to the agenda. We're going to go over the current landscapes, what the current rating areas are, the performance, and any concerns that we saw when we looked at that performance. Then we'll go over the key results with 4 different scenarios that were considered. You can go to the next slide. All right, next. So just as a quick reminder, this is the kind of a visual of the current rating area landscape. Rating area 2, you will notice, is not contiguous. This reflects the current method or the old methodology that insurers were using when they were putting together their rates. If you'll go to the next slide. We looked at calendar year 2020 data, and we want to caveat that this has not been adjusted for the ongoing COVID-19 pandemic. And then just to orient you to the table, this is individual and small group ACA business combined. On the left, you've got the rating area. Then you have the average members that were in this area for all insured business in the ACA market. The distribution of that membership, premium per member per month, which has not been adjusted for age or benefit differences between the rating areas. A premium differential, which has been adjusted for age differences and benefit differences, and then a medical cost ratio. We want to reiterate that medical cost ratio is not the same as the minimum loss ratio requirements in the ACA. This is really just claims and risk adjustment for 1 year, and that year is a little bit odd because of COVID. What you'll want to notice about this chart is urban areas, so rating areas 1 and 2, are more competitively priced than rural areas, with significantly lower premiums, even when adjusted for age and benefit differences, as compared to especially area 4. Urban areas also have a significantly higher medical cost ratio than their rural counterparts. So they have lower premiums, and more of those premiums are going to claims costs. This makes sense because competitive pressures lower rates, which increases the medical cost ratio. Thus, companies may be subsidizing expenses in urban areas by charging higher rates in rural areas. We want to reiterate that as a may. We do not know that that is what they're doing because we have 1 year of data.
Ms. Tolman, can you explain the difference between the medical cost ratio and a statutory medical loss ratio?
Sure. So this medical cost ratio includes claims expenses, so expenses that go directly to hospitals and providers for cost of care. And it also includes risk adjustment, which is a program through the ACA that transfers dollars to help compensate insurers for differing levels of risk. The MLR is done on a 3-year rolling basis. It also includes some adjustment for things like quality improvement. So that gets counted as in the numerator. It includes some adjustments for taxes and fees, et cetera. So I wanted to reiterate that since the minimum loss ratio requirement is 80% for individual and small group. So we don't want to imply that insurers will not hit that minimum loss ratio on their 3-year rolling. 2020 was a very, very weird year. So just wanted to point that out. Does that answer your question?
Yes, I think it does. I think I'd love to see the MLRs for these as well. And I'm curious whether our Bureau of Insurance, and I think I'll have to ask Ms. Hooper this later, would require rebates to MLRs that fall below 80% by area, or if they only do it generally. I realize you probably can't answer that question, Ms. Tolman. That's a question for Ms. Hooper later.
Okay. Moving on. So then this next slide is a similar look, but it's really only for rating area 3. So there's a noticeable split in performance between Androscoggin, Waldo, Franklin, and then Penobscot, Somerset, and Piscataquis. I hope I said that right. And then what we've noticed is insurers are splitting rating area 3 themselves by varying service areas and networks. So when insurers are putting together their plans, they can kind of put together separate networks for different areas based on the hospital systems that are available, or define their service areas as smaller than a rating area. And so it looks like some insurers are doing that. Ones that are not, Penobscot, Somerset, and Piscataquis, are being subsidized by Androscoggin, Waldo, and Franklin. Any questions on this slide? Okay, we'll move on to the next slide. And you can, yep. So the first scenario we considered is keeping the current rating areas. We found if we do some more extensive rate review to analyze those area factors, area 4 rates could decrease on their own by 23%. Based on calendar year 2020 data. So again, this could be different if you look at more years of data. The pros of this, besides reducing those rates, are minimal disruption to the state and to the market. There's no justification to the Center for Medicaid and Medicare Services. And then rating area 3 would also see potentially a decrease in their rates. The cons, it doesn't address the concerns about the noticeable split we're seeing in the counties for rating area 3. And there would need to be a rate increase of 6 to 7% in areas 1 and 2 to keep insurers revenue neutral. Another thing I want to point out as we go through these scenarios is that insurers have many tools at their disposal, including the service area and networks that I mentioned before, to differentiate rates and to remain competitive. Depending on the actions that you take, insurers could also exit counties that do not financially make sense for them. So the results quoted on this page assume the totals for the insurers remain the same and do not consider other actions insurers may or may not take to any changes made in Maine. And the scheduled merge market may also produce differing results than what has been estimated in the modeling. So this is stay the same, but do more a rate review to analyze area factors. So potentially pushing those area 4 rates down. Any questions? Looks like
Representative Matheson, go ahead.
Thank you, Madam Chair. I just wanted to clarify, you had said in these rating area analysis, it does not include the combination of could you repeat that? You said
it doesn't consider the merge market.
It doesn't.
Right, but we did combine small group and individual data.
Thank you.
So we tried to estimate it as close as possible, but it doesn't consider what could happen with your merging of your markets.
Senator Stewart.
Thank you, Madam Chair. So in regards to the Area 4 decrease, were you able to see what was driving that back in 2020?
What was driving the necessary decrease? Sorry, I just want to get clarity.
Good question. Because I think that's what I'm trying to do too, is to figure out with the decrease. So without, this is assuming there's no change at all, right? Year over year.
Right. Yeah. So could we go back to slide 5? I think that will help. So if you look at rating area 4, they're being charged $819 on average for their premiums, but their medical cost ratio is only 55%. So we said, well, what if we put that at the statewide average of 72%? How much could premiums come down? So that's where we got a 23% decrease. The other numbers quoted on that other slide we were just looking at are similar. So for rating area 3, if we move to a 72% medical cost ratio, we could come down, I think, 4 to 5%. And then rating areas 1 and 2, you would have a slight increase in the rates to get down to that 72%. Most states in 2020 had lower medical cost ratios than they would have seen in prior years. So I would anticipate that normally a 72% isn't typical. It's probably closer to that 80%, which is why I wanted to add that distinction about the MLR. So thank you for your clarifying question. Hopefully that cleared up some things for everybody. All right, if we could go back to slide 8. Oh, we can, yep, we'll go right to scenario 1. So the first scenario we considered is keep 4 rating areas because that requires no justification to CMS, but move Penobscot, Somerset, and Piscataquis to rating area 4. So what this does is it has more members in rating area 4. So perhaps insurers will decrease rates to get more competitive. And assuming that's what would happen, you have a 19% decrease in the current rating area 4 counties, which are Hancock, Aroostook, and Washington. And then a slight decrease for the counties that get moved over, Penobscot, Somerset, and Piscataquis. The cons are kind of the same that we had before. You have rate increases of 6 to 7% in areas 1 and 2 to keep insurers revenue neutral. It doesn't necessarily address some of the ongoing concerns between rating area 3. So if we move to scenario 2, we could add a rating area. This would require a justification to CMS because they allow for your rating areas to equal the number of metro statistical areas plus 1. So you've got 3 MSAs. and you add 1. So you're allowed 4 without a justification. The pros of this, it's maximum flexibility for insurers. You're really putting your areas that seem to be aligned together. Area 4 rates could decrease 23%, and your Area 3 rates could decrease 15 to 16% for your new Area 3, so Androscoggin, Waldo, and Franklin. Again, justification to CMS would be required, and we have similar issues as before. I think there's a question.
I don't see committee members' hand raised. Oh, yes, Representative Evans. Please go ahead.
Thank you, Madam Chair. I think she may have answered the question. The question has to do with the CMS justifications. If you chose this model, what are the chances of CMS approving? You have any idea? Or?
I do not know that. Marty, do you have any idea?
Yeah, I can speak to that. We don't have the specific guidelines in front of me, but basically we do need to put a proposal before CMS. And as long as we have the actuarial justification and it meets the requirements, then it's a process that we go through. So this project gives us the analysis that we would pass on to CMS. I think CMS has encouraged states to keep the number of rating areas lower. So they're less inclined to approve if we asked for every county, and asked for 16 areas. I think we have a pretty good chance if we requested, just 1 additional.
Thank you.
This also reflects what insurers appear to be doing when they're filing their networks and service areas. So I think that would be another boost in your application to CMS. I believe Representative Arford, do you have a question?
So what I'm trying to do, by the way, thank you so much for this. It's really interesting and informative. I'm trying to understand how this would actually present itself in the actual premium amounts that you showed us 2 slides ago. So is this actually going to bring if we were to go the 5 rating area model, would that actually bring all the premium dollars into alignment within those 5 areas?
When you say you mean within the area, they would be a lot closer.
They would all be paying about the same amount.
Just changing the rating areas, I don't think will, but Marty already noted they're looking at analyzing area factors more closely. So that should help bring the premiums more in alignment. You'll always have some differences because consumers choose different benefits. And then, the age factors also play a role. To the extent that hospitals and providers cost more in certain areas than others, that will also be reflected in your rates. This is a little bit giving away the next slide, but we did notice that the rates look like they could be a lot closer together than one would maybe expect in other states.
Is that what the next slide shows? Is that the next slide?
The next slide, we looked at 1 rating area because I believe that was to address a question for the proposed legislation of what if we just had 1 rating area, or what if we limited our area factors to, 1.25, I think, eventually. That's kind of what the next scenario was addressing. So to answer your question, the rates could be a lot closer, it looks like, and have the same kind of underlying medical cost ratio within each rating area. But I don't think they would be exactly the same when adjusting for age and benefits, but much closer than they are today.
Thank you.
Mm-hmm. And again, I will throw out the caveat, this is based on 2020 data, and 2020 was a weird year, as we all know. maybe we'll move on to the next slide then. So this is looking at one rating area. This really resulted in decreases in rating areas 3 and 4, so 3 to 4% and 21 to 22% respectively. The old rating areas 3 and 4, that is, and then rate increases of 4 to 7% in areas 1 and 2 to keep insurers revenue neutral. As you may notice, these numbers are pretty similar to what we were quoting on the previous slides, which gets to Representative Arford's point that maybe the rates would be a lot closer overall. The cons of this are it provides minimum insurer flexibility. And this is all a little bit in a vacuum. We don't know exactly how insurers would react. They could decide to go with narrower networks and narrower service areas to create their own pseudo rating areas. They could exit unprofitable areas if they don't feel like they can really subsidize those areas. And then it could discourage expansion. My specific concern would be if you have any small regional players that have to provide for the entire state or feel like they can't get as competitive in other areas, they may just stay in their one region and not try to expand. So it could lead to a backlash if insurers feel like they have less flexibility and less opportunity to take chances.
Ms. Tolman, I have a question. What do you mean by discouraging expansion? Whose expansion? What expansion?
Good question. So if you have, let's say you have an insurer who's currently in, let me pick a county. We'll say Cumberland County. You know, they're in a pretty urban area and they're looking at, maybe I want to expand into Knox County or Kennebec County, but they don't have all the contracts in place with the providers to be as competitive. If they have to use the same rating area factor in both of those counties, they may say, well, I don't want to lose my competitive edge in Cumberland County, so I don't think it's worth the risk of expanding into Knox County because I can't charge more to reflect my contracts that are worse. Does that make sense?
Yes, thank you.
Okay. Thank you. You guys are asking great clarifying questions. Any other questions on this slide? Oh, go ahead.
Representative Evans, go ahead.
Yes, thank you, Madam Chair. My reaction to that would be that the expansion has already occurred with we were told of, I think, around 37 hospitals in the state and at least 4 major systems. So those systems are incorporating all of those smaller rural hospitals. So there wouldn't be any significant reduction in their ability to expand.
I think she's referring to the insurer's expansion, not the hospital.
No, okay, all right. Okay, that makes a difference.
Yeah,
Thanks.
apologies, I wasn't clear.
Okay.
Any other questions? The next slides are really just our appendix and our kind of a review of methodology and limitations. We don't need to go through them in a lot of detail, but I would like them to be shown on the screen just so you have a chance to glance at them. All right, anybody need me to stay on this slide? Can I move on to the next one? Limitations. This is all the actuarial jargon, so if you have any questions, let me know.
Ms. Tolman, can you talk about why our provider networks, which are pretty limited in the state, given that we have 4 basically major hospital groups for the entire state, weren't considered when you talked about the impact of geographic rating? Because I'm wondering about that in terms of what you talked about in terms of insurer expansion, because their contracts are with the big groups, not with the individual hospitals, I think. I guess that's one of the questions. Like, a contract with Maine Health includes many hospitals up north. Same with Northern Light. So I guess I'm just confused about how that's a pretty important impact.
Marty, did you want to
Yeah,
add
I
something?
I can probably jump in. I'm not sure I can speak too much to it, but from my review and understanding of the plans that are offered by carriers, we do have some carriers that have limited offerings. I can think of like Aetna Health, and also the types of plans that get offered. My understanding from reviewing those plans, that there's some with like a tiered offering. So you have a preferred network and then a non-preferred network, and they're not able to offer that type of plan up north because for them to have adequate networks, they aren't really able to offer a narrow type of network. So it's one of those things, we talk about health insurance is complicated. It's ways that carriers have been trying to structure their plans to get the most bang for the buck. They contract with providers to try to promise them perhaps a certain utilization. And so it's all involved in the provider networking. And that's a piece that's hard for us to get a grasp around. So we're making the best of the data that we have available. The Bureau of Insurance does not review, let's say, like provider contracting, the agreements that are made with the carriers. But we are aware that there's some differences there. And that's a way that they can distinguish their products and also have some different pricing structure. So hopefully I didn't go down too much of a rabbit hole with that answer. But that's my explanation of how things differ in the different service areas.
And I'll just pop in really quick before we go to Representative Evans' question. With my experience, which is not Maine specific, but I've worked in a lot of states where there's dense urban populations and, also very rural populations. And what I found is, I worked on the insurer side, so I'm biased, that, if there's one hospital in a region, you have to have it in your network. You don't have a choice. You've got to have it. So, in areas where there's more hospitals, even if they're a part of the same system, sometimes the insurers can get better contracts because of competition than they can in outlying areas where they have to have a hospital in their system. And then they also have to contract with potentially fewer primary care providers and specialists who can perhaps demand higher rates of pay than in an urban area where there's more competition. So hopefully that helped add to what Marty had to say.
I think it did, and I'll move on to Representative Evans' question.
No, she answered my question. Thank you. Thank you, Madam Chair.
All right, the last slide we have is just the actuarial disclosures. So really tiny actuarial font, as I've heard people call it, just listing kind of all of our professional requirements. So I would open it up to any other questions anyone has.
Are there further questions from the committee? Yes, I see Representative Blyer has a question. Go ahead, Representative.
Yes, thank you, Madam Chair. My question is the comment has been made a couple times that last year was an odd year because of COVID. Wondering if that might have skewed the numbers, and how much? If you think it's minimal, should we have a look back, at some point to make sure that whatever scenario we choose today was the right direction? Just.
And Marty, Jackie and I discussed this. We looked at COVID and said it looks like over the course of 2020, areas were probably affected similarly. But as you are probably aware, the ACA market has kind of been on a roller coaster since it started. So I would always recommend considering more data as it becomes available. That was just outside the scope of this particular project. And I don't know if Marty, you want to add anything to that?
Yeah, that is something that we wanted to look at. I think, certainly those of us in Maine have been following the news on COVID and saw some, it seemed to hit Cumberland first. And, there were other counties like Aroostook. And I don't have it in front of me. I'm not CDC, but, just as a layperson looking to see how COVID had affected, it did seem to, it took a while before it penetrated the full state and the full effects. And with 2020, because there was the actual shutdown, you weren't able to go. There is reduction, and we have that in some of our data. We just haven't put it together yet to show that perhaps the utilization rates were different in the different counties. So that's why I caution. We knew that you had to review this particular bill, and I had promised to bring you some information. So I felt like this was a good start to let you know we are looking at some different options for geographic rating, and I will have more data available when it comes to rate review. But we would like to include some more claims experience and also understand that there are other factors. I am concerned about future provider contracting changes due to COVID. We have started hearing that, certainly you hear it in the news, visiting nurses, lack of healthcare workers. So, there's other impacts that could be coming up as well.
Ms. Hooper, can you answer the question I tried to ask in the middle of the slide presentation, which is about whether or not the Bureau analyzes medical loss ratio by area, and if so, do you request rebates on that basis for particular areas?
Yeah, I can answer that. Thanks for reminding me. I had written it down and had fully intended to give you an answer. So the federal MLR requirement is monitored by the feds as well as the state. So when a carrier calculates that, there's a federal prescribed form that they file, but I also get a copy of it, so we do have oversight. But it is by block of business, not by the geographic area. So I hear what you're saying. If there were a discrepancy, it would not get picked up by the MLR. It's all aggregated. And part of that's due to credibility. So what we've noticed even more so in the small group market is there's certain counties that don't have that credible experience. And I think we've talked about credibility before, where if you don't have enough claims, enough people covered, then just numerically, it's not reliable enough to require a rebate. So we do have information by area. And like we said, that's something that we'll be using for rate review. So I think we would be able to address it through rate review rather than the MLR rebate. But we do have the rebate by block of business. So does that help?
I'm not sure what block of business.
Oh,
means.
sorry. Okay.
Okay, so
they-
that's a bit confusing, but
Yes.
also, so rate review happens with that in mind, with the areas in mind.
So, right. So block of business, I'm sorry, I meant it means we have individual and small group. So
Okay.
The carrier is required to meet the minimum loss ratios for the carrier's particular individual Affordable Care Act plans. And they aren't required to meet it for each geographic area.
Yeah, because it does look like there could be a very realistic concern about the medical loss ratio issue in certainly in Area 4, which is Aroostook and Washington counties. And I mean, just on the face of it, it looks like those folks are really being terribly overcharged and subsidizing some of the lower rates in other parts of the state.
Yeah, and that's why we caution too that this is 1 year. I did look back. We did a geographic factor or geographic rating report back in 2012 at the beginning of the Affordable Care Act. And at that time, I think I had loss ratios from Harvard, and they showed that Area 4 really was quite high. So there can be changes over the years. And you know, once again, that's why like medical loss ratio uses an average of 3. So this report is, or this analysis is helpful because it gives us a chance to investigate more and pull in some more data to look to see if that is still a problem.
I'd like to just add on to what Marty has said about credibility. So in rating Area 4 for individual and small group for all of your insurers, we're looking at less than 11,000 members in total on average. A rule of thumb for actuaries is 2,000 members would be credible. So if you think about it, you're spreading out all that membership across 2 markets and several insurers. They may not have enough data to justify lowering their rates. And so I think that's where Marty can step in their rate review. Because now they've got all this aggregated information.
Thank you. And Representative Evans has a question. Go ahead, Representative Evans.
Thank you, Madam Chair. I think you mentioned this earlier already. How often does the rate review occur? Did you say around 5 years?
So for the Affordable Care Act plans, we do review the rates every year. And it's
every year.
Yep. And it's right around June, July for the next January. Yep. So we're usually looking at 1 full year behind and then catching up with the current year.
So, yeah, are there other questions from the committee for either Ms. Hooper or the consultants, Ms. Tolman, Ms. Young? Seeing none, assuming that Representative Evans' hand is left over from his last question, I would suggest to the committee that this is a lot of information to digest and that maybe we're not ready to take a vote today. So I would entertain a tabling motion for this bill, and you know, we need to think on it a bit. Yes, Representative Stewart.
Thanks, Madam Chair. I'm certainly happy to make that motion because I agree. I think making any action today probably wouldn't make a lot of sense. But one thing I think to try to move the process along on this bill a bit would be to get maybe like a straw poll sense of where folks on the committee are at. And I think the first question is there a consensus to do something this year? And then, you know, beyond that, what that something looks like, we can maybe meet offline as a group and sort of bat around or something. I'm not really sure how to proceed on that.
I don't think that the Democratic caucus has reached a consensus of any kind on this bill yet. I think that even with this data from 2020, I'm not sure that we have enough information yet to make a definitive decision. If there's someone else who'd like to weigh in, I'm fine with that. I think what I do recognize is looking at the costs that at this point, Area 4, which is the area you represent, is certainly being charged a lot more than the other areas, and that probably it's worth doing something to assist with that. But it's unclear whether that's something that we want to leave to the BOI in terms of adjusting the areas, or whether that's something we want to do by statute. Does that make sense, Senator Stewart?
Yeah, yes, I would agree. I think that's helpful on my end to just know that much. If you're ready for a motion, I'm happy to make that, and we can try to chew on it some more.
Is there any further discussion? Yeah, it looked like Representative Evans wants to say something before we move on. Go ahead, Representative Evans.
Oh, I was going to second his motion, Senator Stewart's motion.
Oh, he hasn't made a motion yet, Representative Evans, so let's.
I thought he did.
No, he said if I'm ready, he would. And I just wanted, because tabling motions aren't debatable and usually we don't have more discussion after, I wanted to make sure there were no other comments or concerns in the committee. But seeing none, go ahead, Representative Stewart.
Thank you, Madam Chair. I move to table this item.
Thank you. And Representative Evans, would you like to second?
I second that motion by Senator Stewart.
Thank you, Representative Evans. So it's been moved and seconded that we table this, and as a procedural vote, we'll do as we've done before and have our hands in the box, please. Okay, I see no one not raising their hand. So the motion is that we have tabled this bill, LD 1331, and we need to sort of think about it and perhaps talk a little bit more with the Bureau of Insurance about it. And maybe have Colleen, Ms. McCarthy Reed weigh in a little bit on what we've seen and heard as well. All right, so that brings us to the next bill on our docket, LD 1628, an act to exempt nonprofit agricultural membership organizations from insurance requirements. And I'm going to see if Colleen has any further comments on this. We received her bill analysis last time we worked this bill.
That's right. So I haven't updated the analysis on LD 1628, but this was a bill that we carried over to allow the sponsor and some of the interested parties to have some additional discussions about the proposal. As it was drafted, it would have made some changes to exempt agricultural associations from some of the requirements related to health insurance. And I think maybe perhaps Senator Stewart or some others might be here in the attendee space to update you on where things are with LD 1628.
Senator Stewart, do you have an update for us on this bill?
Thank you, Madam Chair. So in the interim, I've been working with the Farm Bureau, the Maine Farm Bureau on this bill, who would be, for all intents and purposes, the entity that would be working on these plans for their members across the state. I see that Julie Smith is in the attendees. If it would be possible to bring her over to share about the conversations that she's had with her board and her membership in the interim about this idea, and the support behind it and that sort of thing. That would be, I think, what I would like to do next, if that's okay with you.
That's fine. Go ahead and bring Ms. Smith over to talk about that. Welcome, Ms. Smith. Go ahead.
Thank you so much, Representative Tepler. My name is Julianne Smith. I am the Executive Director of the Maine Farm Bureau Association. I think I wanted to emphasize that this bill was created in conjunction with Tennessee Farm Bureau, one of our sister organizations, and it's specific to Farm Bureau because we don't want any sort of entity being able to offer a plan like this. This is a plan that has been in existence for several decades. So we're essentially joining into an existing program that has been very helpful and successful for many farmers who are not able to access affordable health care through other avenues. And so we spent the summer surveying our members, talking to members, finding out what they have for health insurance options, and finding out where the disconnect is that they need. And the primary concern was just affordability. And even through the insurance marketplace, there just is such a gigantic lack of affordability. Either the plan is somewhat affordable, being between $100 and $300 a month, but then has an enormous deductible, $10,000 to $20,000, which, especially for our young farmers, is simply not feasible. They don't have $20,000 in the bank when they have a health emergency. And so we've worked very diligently to listen to the concerns. We've had farmers meet with representatives from the Tennessee Farm Bureau that administer this program, and asking those questions that you asked a year ago. I know that was a long time ago, but asking, are we going to get kicked out for pre-existing conditions? Are rates going to jump up if something happens? And they were able to assure us that no, that is not what happens with this plan. The simple reality is that once you are on the plan, you are there until you choose not to be, or an event chooses for you to not need a plan anymore, such as death. So we really feel strongly that, this is not going to have, there aren't thousands of people in Maine that are going to be benefiting from this. It's just a few hundred farmers. And the secondary effect of this is that this type of program allows farmers to offer it to their seasonal employees, which is a very big impact. A lot of times with farms, there's a requirement that a worker has to be there for a certain period of time before they can offer insurance. And that would make a huge difference for the seasonal employers. So instead of, an employee starting in April and not being eligible for health insurance until June, they're able to start April 1st and apply into the program April 1st and hear back shortly thereafter if they're eligible, and then have health coverage immediately. So we do feel in our analysis that we've done as the Maine Farm Bureau Association, in our conversations with other states that offer this, it's not just limited to Tennessee. There are, I think, 6 other states that offer this program, that it is 100% comparable to any insurance offering that exists in the state of Maine. But it just provides a level of affordability because it covers so many states and has so many inputs into it, that it's something that it basically has more people on the program so they have more income to be able to cover more things in an affordable way, essentially my understanding of it.
Thank you, Ms. Smith. I guess I have a couple questions, but I'll let Representative Matheson go ahead of me. Representative Matheson, please go ahead.
Thank you, Madam Chair. So this healthcare benefit, how is it regulated?
So we would opt in to having it be regulated by the state.
Under the Insurance Bureau?
Yes.
Ms. Smith, if it would be regulated by our Bureau of Insurance, why do you require exemptions from insurance coverage requirements for it to move forward?
I will be honest and say that is a technical question that I am not sure of, so I'm going to do my best to answer it. I may need to send you a correction later on, but I believe because the program does an initial screening where they may say, we're sorry, we can't afford to offer you coverage, that is the exemption that is that this bill allows us to be able to offer this. So I think essentially, if there were any disputes or concerns about anything that was happening with someone who had the Farm Bureau coverage, they would have the ability to go to the Bureau of Insurance with any complaints or concerns.
Do you know on what basis people are rejected from the program? Because that sounds like a pre-existing condition exclusion to me.
That I cannot answer. I know the percentage is very low. It's below 10%, but I cannot tell you what the basis is.
Yeah, okay, well, that's a huge concern for me, just letting you know. All right, please, Senator Brenner, go ahead.
Goodness. Thank you, Madam Chair. I guess I have a question, maybe not for Julianne Smith, but perhaps for our superintendent. Just curious if he might be able to share some insight into the idea that if we opt to unregulate this particular product, there aren't any guarantees that I can see that a person would then have the capacity to go to the Bureau of Insurance to complain about a service that is unregulated by the Bureau. So I guess I would like to hear his response to that idea.
Thank you, Senator. I see that the superintendent has his hand up, so if we could bring him in, we'll hear his thoughts on that. Welcome, Superintendent Chapa.
Good afternoon, Representative Tepler. There's still a lot of unanswered questions about this in my mind, you know, especially starting with the financials of the entity and what authority we have. I mean, clearly under entities that are subject to our jurisdiction, like a MIWA, there's joint and separate liability, and we review the financials annually. Insurance companies have risk-based capital, which triggers action against a company if their risk-based capital is far below an amount. And what I'm really saying is that's fundamental in the ability for us to judge the claims paying capacity of these firms, because this company would not be a member of the Guarantee Association. So there could be, and I'm not saying there would be, but there could be unpaid bills if it failed, and we don't have the regulatory. I understand this, and we would not have the regulatory authority to intercede if the company's financials were impaired, and that's always a concern. And you know, I'm not sure it gives them advantage, medically underwriting, but I don't see that as a substitute for sound, the authority for us to review balance sheet and income statements and make sure that it's a strong financially sound entity able to pay claims.
Thank you, Superintendent. So shorthand of what you just said is if the firm goes bankrupt, regardless of how much people have paid in, they may not have their claims paid.
Correct.
Thank you. All right, and Representative Evans, go ahead.
Thank you, Madam Chair. Ms. Smith, I'm going back, I think, to what a question
Representative
that.
Evans, I'm going to interrupt you and say, I think what I'd like is for questions for the superintendent to come first, and then we'll go back to questions for Ms. Smith, if that's okay.
That's fine.
Senator Brenner, do you have a question for Superintendent Chapa?
Thank you, Madam Chair. I do. Thank you so much, Superintendent Chapa. I'm wondering if you could also speak to the managing a plan from Tennessee, from Maine, after the client pays their premium. Would the plan be able to change the parameters of what they're offering? And would we have any capacity to engage in that if there's a dispute as a bureau, or with a deregulation of this particular product? Would we lose that capacity to support our consumers?
It's unclear to me, but if it's not subject to Maine law, there's guaranteed renewal. They can't change the terms of the policies under an existing policyholder unilaterally. And if those laws didn't apply, they could change the coverage parameters, and yes, they could change them without requiring our approval.
Thank you.
Does anyone on the committee have further questions for Superintendent Chapa? Seeing none, thank you very much for your input, Superintendent. We'll send you back to the attendee space. And Representative Evans, if you want to go ahead and ask your question of Ms. Smith, please go ahead.
Thank you, Madam Chair. I just wanted to go back. Am I understanding correctly that some people may be covered, whereas other people may not be covered?
That is correct. So there's an initial application process. And then after the application is approved, you are covered up until you choose to no longer be insured. But there are about less than 10% of the applicants who are not eligible for coverage.
And to follow up on that, how do you determine who gets coverage as opposed to who doesn't get coverage?
That I would have to ask from Tennessee Farm Bureau. I don't know what their determination factor is. But we certainly would, be amenable to amending the bill in a way that says that essentially we're not going to change things midstream. We're not going to change our coverage in any way that would be different than an insurance policy in Maine. We simply want to have this option because it is a very flexible option for our farmers to be able to take part in.
Thank you. Thank you, Madam Chair.
Yes. Go ahead, Representative Melorano.
Thank you, Madam Chair. I think we should probably remember that 10% that won't get coverage are probably the older and sicker farmers that will get excluded from ever having coverage at all in this plan. I feel like as a society, we're trying to move away from that sort of thing. So that's one of the reasons I'm concerned about this bill. But I think, we do need to remember that it will be the older farmers and the farmers who have pre-existing conditions who will be that 10% that they won't be able to get coverage, the ones that probably need it the most.
Okay, Representative Melorano, are you all set then?
Yes, that was just a statement. Thank you.
Yes, well, we're in work session, so that's okay. And Senator Brenner.
Thank you, Madam Chair. Ms. Smith, I'm wondering if you could tell us a little bit about how one becomes a member of the Farm Bureau with regard to, are they actively engaged in farming, or can anyone join the Farm Bureau?
To be a full Farm Bureau member, you do have to have 50% or more of your income from agriculture.
So what does a non-full Farm Bureau member look like?
So that is someone who we consider them a farm supporter. And there's a distinction within our database of who are farmers and who are non-farmers.
In other states, is that category of membership able to access this insurance product?
I don't know the answer to that.
And would that be the case here in Maine? Would that be in your supporters and your full members would be able to access the product?
I believe we would only offer it to the farmers.
So you would only be offering it to your full members who
Correct.
are receiving 50% of their income from agricultural activities.
Yes.
Okay.
Can I follow up just a second? I heard you say, I believe. So is that a definite or not a definite?
I mean, we would not be advertising it or offering it to non-members. So I unless there is some rule or law that I am not aware of that would prevent us from saying you have to offer it to every member equally, we would only be offering it to our farming members as a benefit.
Okay. Thank you for that clarification. And Senator Stewart, please go ahead.
Thank you very much, Madam Chair. I just wanted to jump in because it is a work session and we're just, talking about different ideas here, and just to address a couple of the points that have been brought up. The big one being the issue about what if an application is denied? Nobody is saying that these folks should go without insurance. And in fact, there will be insurance available for them on the exchange that they could go out and get coverage for. And we're not suggesting that we do away with the exchange and just do Farm Bureau plans. But we're saying for this small subset of folks, this can make a big difference in their lives. And it could be the difference between them purchasing insurance at all. And then if they're not, then they're going completely uninsured. And that's not an outcome that I think anybody wants on this committee either. So, another point to bring up too, is that as inflation continues to, drive up the cost of food and goods in our country, this could be a way to help keep some of those costs lower by providing health insurance to folks that are working on these farms by at a lower cost than they would be able to get under the current system. So just some things to chew on.
Thank you, Senator Stewart. I have a question for you, Ms. Smith. Can you explain to me why the Farm Bureau hasn't considered creating a MIWA over all this time? I mean, this is something our state has. The superintendent supports. It gives a group of people who are gathered together the opportunity to negotiate with an insurer, to create a plan that serves them. And I know that, for example, the auto dealers have a MIWA. Why can't farmers have a MIWA?
Well, I think that the simple answer to that is management and finances. As Maine Farm Bureau, we don't have the staff available to assist with that. And Tennessee.
Ms. Smith, I'm sorry, you just cut out and we can't hear you. Whoops.
Apologies.
Your internet is back now, I guess.
Partnering with Tennessee Farm Bureau, who has a very large program, a very large bank account to back that program. That's what makes it possible for us to be able to offer that to our farmers, because it doesn't require a lot from our office. Offering a MIWA is something that financially and staff-wise, we could not afford to do.
Can you tell me what the annual out-of-pocket is for this program?
I do not know that. I'm sorry. I can certainly have Tennessee Farm Bureau send you that information.
Okay, I guess I'm shocked that you're considering adopting a program for your members where you don't know what it'll cost them out of their pocket on an annual basis.
Well, I don't think it's a set amount. You know, I think it's very similar to any insurance program where it's going to be based on, you know, age. I mean, my insurance changes every year the older I get. So I would assume it's the same with that.
But you don't know.
No, I do not know how financially they structure their offering.
I mean, on the ACA, for example, if you have a bronze plan, you know that your possible out of pocket is up to a certain amount.
Mm-hmm.
And that's the most they're going to require you to spend out of pocket. And it doesn't matter how old you are or how young you are if you buy that particular plan. It doesn't vary by that. So I am confused that you don't know what your members might be paying out of their pocket for this affordable insurance, because that's a very important consideration. Senator Stewart.
Thanks, Madam Chair. And just to be clear too, this bill in no way binds anybody to any plan. This bill simply allows these plans to be sold to members of the Farm Bureau in Maine, and doesn't require them to do just that. It just provides an option that if you are a member of the Farm Bureau in Maine and you're a farmer and you would like to buy into this plan, and if it is more affordable for you and your family and meets your needs, great. If it doesn't, go buy something else on the exchange. But it's really just an opportunity to have more competition in the space, and a product that probably will be more attractive to folks in that subset.
Senator Stewart, I guess one of the concerns that this committee has had overall with health insurance is that consumers are often not fully aware of what they're buying or what their costs will be. And one of our jobs as a committee is to protect them from some of those issues that are very complex that they may not be able to understand from an initial offering with the word affordable attached to it. So I'm very concerned about making this exemption to our consumer protections in Maine health law. Yes, Representative Brooks.
Yeah, I would tend to echo that. And for Ms. Smith, I do appreciate your efforts to try to increase insurance coverage. But I am fearful of that unintended consequence of decreasing the quality of coverage. And I'm not sure if I would be prepared to make a motion, but I know there's more discussion that I don't want to cut off.
Senator Stewart, please go ahead.
Thanks, Madam Chair. I mean, I guess I just, in thinking about your comments a minute ago, certainly if there are bad actors, that could be a role of government to jump in. But at the same time, we don't want to over regulate to the point where there is no competition, to the point where consumers are just left to buy whatever anybody, whatever the government says that they can buy. I mean, I think, and maybe that's a fundamental philosophical difference, right? About what the role of government and what this committee can and should be doing. I mean, a part of what
Senator Stewart, do you believe there's a free market in health coverage?
Well, you're going to have to define free market for me, because I think right now, what that term means to you might not be what it means to others. I mean, I don't think that when the government over-regulates and jumps in like they sort of have in regards to health insurance, that it's actually free, right? I mean, but At the same time, there's policy decisions that were made because of that. But I think the short answer there is no, it's not a free market, that the government is highly regulating that entire sector of our economy. And they've made conscientious efforts to do that. Whether that's a good thing or a bad thing, I think you got to make that decision for yourself. And there's pros and cons on both sides. But at the same time, this wouldn't be a totally free market in this instance either, because it's a limited subset of people who we're talking about that are farmers and that are members of the Farm Bureau. And we're essentially saying that if it's appealing to you and it meets your needs, you have an option to buy it. If it doesn't, then you could go do something else, right? And hopefully that something else isn't remaining uninsured, which in a lot of cases, that's a lot of the folks that we're talking about here, that they can't afford it on the exchange because of choices that government has made in their regulatory scheme.
Senator Brenner, I'll get back to you in a second. I'm going to ask Representative Morris to go ahead because he hasn't spoken yet. Go ahead, Representative Morris.
Thank you, Madam Chair. Actually, I did have some questions, sort of comments with respect to Julie Ann Smith. Wouldn't a lot of this too, it would sort of be based on how many people decided to join this co-op, and what you're really looking for is all the members that were in there, they'd be putting their money into this as almost like a pool to be drawn from. That's kind of the intent of this, if I'm not mistaken?
That is not, I do not believe it works that way, because this is, their money would be going to the Tennessee Farm Bureau plan. So it's not a main co-op. This is it's basically insurance, but because they do have that small percentage of people that are not eligible, they cannot call it insurance. So there's really no difference in quality or offerings or opportunities with this program. And there isn't that co-op, so you don't have that risk of having a lack of funds.
I gotcha. Okay, that makes more sense. So it would be going to Tennessee. So we must have some idea what the rates are for the farmers down there in Tennessee then.
Yes, and I apologize. Tennessee Farm Bureau was not available, unfortunately, today for the work session. I wish they had been, because they could give you definitive answers to these. And I apologize. I am not an insurance person. I'm a farm person. If you were asking me farm questions, I could answer all of them. Insurance, there were things I just didn't anticipate that I would need to know. So I apologize for not being able to answer all the questions today.
Just along, because you and I have had several discussions in terms of the nature of farming and so forth, and you've often stated that farmers are price takers, not price makers. And so you can just, how this would help in terms of, given that reality, how a program like this would help, given, the fact that you guys, you can't go out to say it cost us this much. Our health insurance went up this much this year, as it always does. So now we have to get more for our goods. It doesn't necessarily work that way.
No. So, and that's, exactly why we have the dairy tier program, which I know this is not the agriculture committee, so you might not be familiar, but the state of Maine works to actually subsidize dairy farms to ensure that the price of milk that they are paid is equivalent to them paying themselves $30,000 a year and the cost of inputs to produce that milk. So there is an expectation, essentially, that farmers live below the poverty line, produce food at an affordable rate, and if they can't, we're going to import it from some other country. So there really is no opportunity. Basically, even federally, they set the price of milk. Farmers can't say, my farm can't go to Oakhurst and say, I need you to pay $28 a hundredweight, but you're only offering me 21. There's no compromise in there. That rate is set federally. So, so there really it's a huge problem for farmers to be able to figure out, how do I afford health insurance? How do I afford, I have to pay my grain bill first. I have to pay for my electricity. I have to pay for water. I have to pay my tax bill. And then if there's anything left over, I can pay myself. And if in paying myself, I've got some money for health insurance or health care. Maybe I have the money for health insurance, but I can't ever go to the doctor because I can't even afford the copay. So it's really a huge struggle, especially in Maine, where we have the shortest growing season in the whole country. And we have some of the highest cost inputs, which even during the pandemic, we saw the cost of fertilizer increase by 125%. Well, we're not going to be able to charge 125% more for our apples and our potatoes. We've got to figure out a way to absorb that cost and keep food affordable, because that's the expectation of people that are buying food in grocery stores.
So just to summarize, it's basically, this would be a huge help because it would give them another option given
Yes.
the reality of farming as you've laid out.
Yes, because unfortunately, where farmers have a lot of land in their applications on the marketplace, it makes them look rich, but they're not. They're independent business owners with a lot of land that is generally mortgaged beyond what it's worth, and so they're generally not able to access a lot of the affordable plans. Our young farmers that may not even own land but are leasing land and farming it that way are finding that they're having such high deductibles that they can pay for to have that insurance. They can pay their monthly bill, but they can't afford the deductible. So it is just it's another option for farmers who do find something affordable and better on the marketplace. We're not taking them away from the marketplace. They're going to stay right where they are. These are just the farmers that are saying, there's nothing on the marketplace for me. There's nothing I can afford. I need something more expensive. And working with Tennessee Farm Bureau, who, just like Maine Farm Bureau, represents all farmers of all commodities and all sizes, their emphasis is on, how do we help the farmers?
Okay, so Senator Brenner, go ahead.
Thank you, Madam Chair. I really want to thank the bill sponsor for bringing this forward and having great concern for the well-being of farmers, being one myself. And I really appreciate Julianne Smith's work with the Farm Bureau, also working on behalf of farmers. Although I'm not a member of the Farm Bureau, I do appreciate her work on behalf of farmers. I spend a lot of time talking to farmers, and what I found is that many of them are thrilled with the care that they've been able to get through the ACA. It has helped them also offer the ability to cover their employees as well. I want farmers to have access to health insurance just as much as the next person. But what I find trouble with in this bill is that the way it's written, you can't control that you're going to continue to work with the Tennessee Farm Bureau and their particular product. This bill is written so that the Farm Bureau has the ability to bring in a number of any vendor they choose, really. So we can't control that it's always going to be the Tennessee Farm Bureau's policy, which we may or may not like if we were to comb through it and feel comfortable with the rates that they were going to charge. In addition, Tennessee Farm Bureau offers it to all classes of their memberships. You just have to be a member and pay your dues. So we may be talking about in Maine the ability for that to be extended to anybody that wants to become a Farm Bureau, which makes me really anxious, because you're talking about extending what I think is a poor insurance product to multiple people who aren't in the agricultural sector. So we're degrading the ability to control the kind of coverage that we think, as we've agreed many times on this committee, is the right thing to do. For example, we pass mandates. We pass mandates for things like extra limbs for recreation for children. We pass mandates to cover mammograms. We pass mandates to cover midwifery care. we would not be able to control that with this product because we wouldn't be able to regulate it. So we aren't going to be able to say that as a committee and as a legislature and as a state, we think that these are things that should be part of a policy for a consumer who's shopping for insurance. Then when someone's unhappy with the product that they get, they're going to look at the legislature and say, how come you let this happen? So for me, in good conscience, this is just not something I can support, despite the fact that I really appreciate the intent to make life easier for farmers. I'm happy to make a motion, ought not to pass for the bill.
Sorry, I'm just checking to make sure I'm unmuted. Yes, Representative Melorano.
Thank you. I'll second that.
Oh, okay. All right. Is there further discussion on the bill? Yes, Representative Brooks. Representative Brooks, you're on mute.
Oh, sorry. A lot of what I was thinking has been said very nicely by Senator Brenner and before with Representative Meloragno, and the concerns about not including, being more inclusive in coverage and quality of coverage. But there is also, in addition, I would just add that the insolvency factor that Superintendent Chopper brought up, that we wouldn't have the that ability to cover in the event that there was an insolvency. And I'll save other comments for more pertinent discussion, but more pertinent bills. But I do think that it's important that we cover people, that healthcare is extremely important, and that this is just a worrisome path to go down. So I would support the ought not to pass.
Yes, Senator Stewart, please go ahead.
Thank you very much, Madam Chair. This appears to be heading down a road of probably a party line vote. I just want to say before we vote that, certainly we agree that health insurance is important. And that's why this bill is coming forward, because there is a subset of folks, particularly in this industry, who have to make hard choices because of some actions the government has taken, which increase the costs on the current system, on the exchange. This is a potential alternative. Nobody's tying anybody's hands by doing this. This is simply allowing an opportunity for more competition in this space to be brought forward, where consumers, and we feel that consumers are smart enough to be able to look into this, see if it's a good fit for them and their family, see if it meets their needs. If it does, fantastic, purchase the product. If it doesn't, move on to the next thing. It's really that simple. We're going to be voting against this motion. Hopefully at some point in the future, we can have another conversation about this.
Representative Arford.
I just briefly want to say I too appreciate Senator Stewart bringing the bill forward, and I do appreciate all the conversation that we've had. I think it has served to further inform the public as to what insurance products are available and what the state actually does to protect the consumer's interest in the insurance marketplace. And the only other concern I have that hasn't been mentioned is that, although extremely well-intentioned, farmers who may decide that this is a good product for them may do so without fully understanding the other products on the marketplace, because this is a complicated market. And if that information is not readily available to them at the time that they were viewing the farm products, then they simply may not be aware of the fact that there might be a product provided on the exchange, or they may qualify for main care that would even serve their interests more efficiently and more effectively. So therefore, I will be supporting this motion.
Okay, and Representative Quint.
Hi, thank you. Okay, so just two comments, if I may. The first one is I have a lot of family members up in Aroostook County who are farmers. I should say my husband's family members, but I claim them as well. who are having difficulties with the prices that insurances pose, and being able to offer them something. Once again, it seems as though the committee is taking upon themselves to decide whether or not people are able to figure out what's best for themselves. We have a lot of young farmers that really can't afford to pay higher insurance costs to offset other healthcare that they don't really need. Secondly, I actually have family members, direct family members, who live in other states that actually have Farm Bureau insurance. So I know that it does work for them, and they would not have insurance otherwise. And so I have a little bit more information on both flip sides of this. Once again, this is offering insurance. This is not saying that farmers have to go get this insurance. But I think having the capability of having that offered, I know for a fact, for my own family, it has allowed them to have insurance in other states that offer this. And so it is something that I would support in having offered here as well. So just my 2 cents. Thanks for listening.
Representative Morris.
Thank you, Madam Chair. I will be opposing this motion as well. I think farming is an incredibly tough way of life. It's very difficult. This is one way to help with their costs of something that's very important, their health insurance. These people, believe me, they know what they're getting into if we pass a bill like this. They are aware of the type of product they would be getting, and I think it's important just because this is a way for them to have some sort of coverage that does not cause their other costs to rage out of control. We are losing family farms in this state, and that's why I think that it is important to do something that gives them some modicum of relief from health insurance costs. And if this program helps them do that, if they find that the plans on this help them do that, it gives them good enough coverage for their family, then I think we ought to let them do it. And I understand, I know your concerns are your hearts are all in the right place. I'm not arguing that, absolutely. We always want to protect consumers. But I think in this case, they are in a situation where they do need this coverage, and this could help them. So that is why I will be opposing this motion. Thank you.
Okay, thanks everyone for weighing in. I just don't think we're going to change each other's minds on this. So I think we should probably just move to a vote. We could keep on arguing, but I'm not sure it will get us anywhere. And we do have a lot of respect for each other. And I might add, there's a lot of respect for our farmers on both sides here. Senator Brenner is a farmer. And I am very close with a number of farmers in my area. I've known Ben Watley of Watley Farm since he was under 1 year old. So, I would like to make sure that people understand that the issue here is not whether or not we want to help farmers. And with that, I will ask Ms. Kafer to call the roll.
Thank you. Senator Sanborn. Senator Brenner.
Yes.
Senator Brenner, yes. Senator Stewart.
No.
Senator Stewart, no. Representative Tepler. Representative Tepler.
Oh, sorry, I muted myself to say yes. Yes.
Representative Tepler, yes. Representative Alford.
Yes.
Representative Alford, yes. Representative Bleier.
No.
Representative Bleier, no. Representative Brooks.
Yes.
Representative Brooks, yes. Representative Connor. Representative Evans.
Yes.
Representative Evans, yes. Representative Matheson. Representative Malorino. Yes. Representative Malarino, yes. Representative Morris,
No.
Representative Morris, no. Representative Quinn,
No.
Representative Quinn, no. 6 members of the committee having voted in the affirmative. 4 have voted in the negative. And the recommendations for the noes?
We can just go with ought to pass. That's probably
Ought to
fine.
pass, okay.
Yep, sure.
Then you're all in agreement. Thank you.
Thanks.
All right, I think it's time to call for a 10-minute break, if you don't mind. Let's take a 10-minute break and come back at 2:02 to deal with LD 1910. So see you all in, I don't know, about 10 minutes. Okay, HCIFS members, please come back into the committee room, turn on your camera. Make sure I have enough folks. Hi, Mark. Okay, I've got Josh. Senator Stewart, are you with us still? Senator Brenner? I need to have one more person in the committee room before I can get started. So Senator Brenner or Senator Stewart, if you're there, please join us. Ah, Senator Brenner's back. Okay, great. All right, so we can get started because we have a quorum, and I'd like to move to LD 1910, an act to improve children's mental health insurance by requiring insurance coverage for certain mental health treatments. And I'll ask Ms. McCarthy-Reed to please present her analysis of the bill.
Sure. This is the first work session we've had on this bill, LD 1910. As Representative Tepler read you the title, but as originally drafted, the bill requires health insurance carriers to provide coverage for mental health treatment services that use evidence-based practices that are recommended by a provider for a child 18 years of age or younger. The bill defines evidence-based practices as clinically sound and scientifically based policies, practices, and programs that reflect expert consensus on the prevention, treatment, and recovery science published and disseminated by the Substance Abuse and Mental Health Services Administration at the federal level. The original bill would apply the requirements to health plans with an effective date on or after January 1 of 2023. There are some provisions in current law that we've talked about previously related to coverage of mental health services. Current federal and state law does require parity between the treatment of mental health services and other health services in individual and group health plans. And essentially parity means that mental health services are treated or have the same terms and conditions under a plan as other health services. There are also, I also wanted to mention that mental health services, including substance use disorder services, is one of the specifically mentioned categories of essential health benefits under the federal ACA, and that's also codified under state law as well. There are also some specific statutory requirements that relate to certain aspects of mental health services treatment for children that were mandated benefits in our state law prior to the enactment of the ACA, and those relate to coverage of autism treatment and coverage for children's early intervention services. So I included those links there for you as well. You have received some additional written testimony and information since the public hearing, and some specific comments that relates to the proposed amendment that Representative Tepler circulated earlier this week. So I wanted to note that, some of which I think came in to the electronic LD file today. But as I mentioned, Representative Tepler has proposed an amendment to the bill to try to address, I think, some of the concerns that were raised in testimony from the public hearing. In the proposed amendment, it would modify the language to reflect that mental health services are covered services under federal and state parity laws. So it moves the provisions or the new language that was proposed in LD 1910 within the existing state law provisions for mental health parity. And it would prohibit carriers from denying coverage for mental health services that use evidence-based practices and are determined to be medically necessary healthcare by a provider, as long as the provider is acting within the scope of their license. It also would increase the age from 18 years of age to 21 years of age, in part to be consistent with main care requirements. And that was something that was included and suggested in testimony from DHHS and also from other proponents of the bill. And then it also would, in addition to mentioning specific evidence-based practices that are included on the SAMHSA website, it would expand the scope of evidence-based clearinghouses as suggested in testimony from the Department of Health and Human Services. And as I mentioned, you have received some additional comments specific to Representative Tepler's proposed amendment. And then originally, when for the original bill, the Bureau of Insurance did submit testimony indicating that the bill, as originally drafted, would be a mandate for any children's mental health treatment services that would not already be required by Maine law. As you know, pursuant to our statute, a mandated health benefit proposal must undergo a review and evaluation by the Bureau before the bill may be enacted. So one thing to consider is whether the bill as amended would require review and evaluation. I think you've received some updated comments today that, particularly from health insurance carriers, that indicate their belief that even the bill as proposed to be amended by Representative Tepler would still constitute a mandate. And the Bureau's testimony did note that they do need time if you were considering asking for a further review and evaluation, and that those typically take at least 8 weeks. I'll stop there. I'm happy to share some additional information, answer some questions or talk about the proposed amendment. I did also share with you some additional information related to efforts at the federal level and also in different states related to compliance and enforcement with mental health parity that came up as part of this discussion on this bill, but also has come up in your discussions about other bills as well. And I guess I'll stop sharing. I'm happy to pull up the proposed amendment if you wanted to look at that language or answer any of your questions.
Does anyone want to see the proposed amendment screen shared by Ms. McCarthy-Reed, or have you all had an opportunity to review it? As the sponsor, I have to say that my hope in having Ms. McCarthy-Reed help me with this redraft of the proposal would be that it would be seen as defining parity rather than as an additional mandate. So parity, particularly in children's mental health. I don't know, I haven't heard specifically from the Bureau yet about whether or not they consider this redraft a mandate. So perhaps we could ask Mr. Yardley to join us to let us know that. Or Superintendent Chapa. I'm sorry, I didn't see that the superintendent was still in the room.
I will bring them both in.
And yeah, whichever one wants to answer the question.
They can figure it out. Superintendent is here first. I don't know if that means he's going to speak or not. So.
Thank you, for coming in, Superintendent.
You're welcome. We're not sure if it's a mandate, to be honest with you. We're still trying to determine that. I'm looking, it's not clear, but it could still be, but we can't say it isn't a mandate right now, but I wish I could be more definitive at this time, but even my staff is of different opinions of it. That's why I'm hesitating.
Okay, I see. So So there's a dispute among BOI staff about whether or not it's a mandate.
We probably should have had this ironed out before, but we didn't. So it would be more definitive, but I think there's room for disagreement as whether or not it's a mandate. And unfortunately, if it does turn out to be a mandate, then we could find ourselves with a bill from the federal government. So ultimately, it's their call in the context of whether or not the state has to pay for a new mandate.
Have we avoided that in the past with some language, given that the federal government hasn't yet collected any of those funds for mandates that go beyond EBH? EHB, sorry.
You're correct. The federal government has not collected any money for the mandate. I'm not sure it's anything the states have done. It's just a decision of the federal government not to collect it, I believe.
Okay. Ms. McCarthy-Reed, you have your hand up. Please go ahead. You're sort of in charge here.
No. I was just going to say that you, in your discussions on some of your previous bills related to proposed mandates or bills where there was a question that you discussed earlier this session, LD 1003, for instance, and LD 1357, which related to postpartum care, you did move forward with enacting or recommending that that legislation be enacted, and added some unallocated language that stated that it was your intent that it was sort of an expansion of those existing provisions, and in your view, it would not be a mandate or an expansion of essential health benefits that would require a defrayal of costs at the state level as a way to sort of help in the event that there might be future discussions with the federal government about whether or not defrayal would be required. So you did that in previous bills, and you reviewed that language earlier this week, I think. So that's something, if you did move forward with this bill or wanted to move forward, you could certainly think about adding something similar with regard to this bill as well. But no one knows whether that works, because as the superintendent said, we're not, as far as we know, no state has been required to defray any costs related to expanded benefits.
Thank you, Ms. McCarthy-Reed, and that's what I was referring to. Yeah, thank you. Is there discussion among members of the committee? Yes, Representative Melorano.
Thank you, Madam Chair. So my question would be, if this is considered by the insurance companies as a mandate, what are they not covering now that is evidence-based and that is needed by the patient and is within the scope of practice of the practitioner? Is there anything in particular that's not being covered? That would be my question for the superintendent or Mr. Yardley.
I'll take a shot at that. This really is a shift. It says if it's evidence-based, and it adds that as a criteria for what it overrules. It basically says if it's evidence-based, medical necessity is not a factor, and that's a paradigm shift from what it is now. It's medical necessity. There's mental health parity, so there is coverage, but this changes what the definition of how you determine what is covered, and that's just a shift. It's a paradigm shift, and how we define what's covered. So I don't think it's an easy answer. I don't think I can say benefit A would be covered under this scenario, and it wasn't covered before, because again, you go to the literature. The literature now becomes dispositive of what's covered, and that's new, and you'd have to go through you'd have to come up with a treatment and see, was it covered before, or what's the literature say? It's just a different way of determining what's covered, and I think that'd be case specific or benefit specific. I can't name any particular benefit.
Madam Chair.
I keep muting myself and then unmuting myself. I apologize. Thank you, Superintendent. For two things. One is I really did think that we made medical necessity part of our amendment. Colleen, didn't that get into the language of the amendment?
It is in the language of the amendment. I think what I think the concerns are being raised is the determination of medical necessity made by the provider, so that there's no ability for the insurer to review that and make their own determination or agreement that that's medically necessary. And so I don't know if your intent is to allow the insurance company, or to have some ability for the insurance company to review that and agree with that determination of medical necessity. Maybe we need to change the language somewhat. Or if you were I think that's the question that folks are raising, right? Whether or not there's an ability for the carrier to be involved in that determination of medical necessity.
If I may, Representative Tepler, right now, the way it works is this, a doctor prescribes a treatment plan and the carrier disagrees on medical necessity. That's what external review is for. The external review program overseen by the Bureau, and this seems to supplement that, as Colleen said, the provider determines medical necessity, and as we understand it, if it's supported by the literature.
So external review, is there a way to include external review in this and yet broaden the definition so that it includes these evidence-based practices that it's my understanding are not currently being covered?
Well, the way the statute's worded now, I don't think so. You'd have to change this the way the statute's worded.
Yeah, I think
the
if
way
you
the
wanted
current
to,
statute is worded, or this statute?
The amendment.
The amendment, yes.
Okay.
Language on my part, I apologize.
Okay. So, but if we change the wording of the amendment to reflect the allowance for an external review, that would be considered not a mandate?
I'm not sure that's a criteria for what it's a mandate. A mandate is a new benefit.
Okay.
So.
All right. Thank you. I see several other members of the committee want to weigh in. So Representative Brooks, please go ahead.
Yeah, I just wanted to share a thought just about how important it is to have parity in this regards. I just think it's a really critical area. I'm glad that Maine was a leader in this area, and we have a chance to strengthen this and to solidify this. And it's something too where it's a science and an art, and it's important where people, especially with our pent up need that we have in our community and with the coronavirus pandemic and other factors, to be able to access the care that they need and that we all need. And so it's just I appreciate the urgency of the situation.
Thank you, Representative Brooks. Representative Evans, do you have a question for the superintendent or Mr. Yardley?
I would like to have Colleen put that section back up so we can see exactly where we're talking about.
Okay, so you're asking to have Colleen screen share the amendment?
Yes, yes.
Okay.
I can do that. Hold on one second.
She can do that. And I hope Superintendent and Mr. Yardley, you don't mind hanging around a little in case there are other questions for you after we look at this.
So the language sort of repeats throughout the proposed amendment, but the proposed language in the amendment would say that insurers may not deny treatment for mental health services that use evidence-based practices. and are determined to be medically necessary health care by a provider for an individual 21 years of age or younger, as long as they're acting within their scope of practice. So I'll highlight it here, but it's not really easy to read. And then it defines what evidence-based practices would mean to be those policies, practices, and programs that reflect expert consensus and are published and disseminated on those clearinghouse, on the SAMHSA website and the clearinghouses that are listed.
And the 3 additional websites besides the SAMHSA website, which is of course the US government website, are the ones that were suggested by our DHHS department in a letter shared with us by Molly Bogart, and also in a letter from Michelle Probert and Todd Landry supporting the bill.
That's right.
Do you have a question still or a thought, Representative Evans?
I don't have a question, but my thought is that this is pretty clear. I don't see it as a mandate. It's pretty clear to me, but that's just my opinion.
Colleen, what do you think we would need to do to these paragraphs to allow for external review by the Bureau of Insurance if there's a disagreement between the provider and the insurer regarding medical necessity?
I mean, I think that you could add some language there that would say that, you know, if the insurer disagrees or challenges or something, you could specifically cite the section related to external review and give the give authority for that to be dispute to be governed under that process. You could also make it, I guess, if you wanted to go further, you could make it subject to all of the sort of utilization review processes that are in place currently, which, you know, would be all the levels of appeal, essentially, you know, in the internal appeal process of the carrier, which would allow for a first level appeal and then a second level appeal to the carrier. And then after that is when, if there's still a dispute, then it goes to external review. But if you just wanted to have it be subject to external review, I think you could amend the language to make that clear. With some further.
I think we need some more discussion about this, because what we're trying to do is create parity. And I guess the question is, do those levels of appeal apply for medically necessary physical health? It's just because we're trying to just create a definition for parity here.
Right.
So,
and the existing law, which is at the beginning of this subparagraph 2, which is where I put this language, gives the reimbursing insurer the ability to request from the provider who's providing treatment for mental illness to provide data substantiating that the treatment is medically necessary health care. And it says when making the determination about whether treatment is medically necessary, the provider uses the same criteria. And so the idea was to put this in that section of the statute where there does give the insurer the ability to ask for data or a documentation from the provider about why they believe it's medically necessary healthcare. And this would give I think the proposal is that if they're recommending services that use evidence-based practices and they believe it's medically necessary, then insurers would be prohibited from denying treatment for those services. But you could change the law, I think, if you wanted to, and say in those instances, insurance companies could request external review, or the patient could request external review, because that's how it works now. Like if the insurance company denies the coverage, then it's the enrollee who makes the request for an external review, which is a process, as the superintendent said, is done through a contract with an outside entity that would review the request for services and make an independent determination about whether the services are medically necessary.
Mhm. So what are folks thinking here? I need to hear more from the committee. Yes, Representative Morris, please go ahead.
Yes, thank you, Madam Chair. I think given Superintendent Chapa's comments, obviously there seems to be some confusion and some, it's up in the air, some debate over whether or not this constitutes new benefits and would be subject to a mandate review. Obviously, the statutes in place requiring a mandate review, and if that is, if this does constitute a new mandated benefit in the opinion of the Bureau of Insurance, we would want that review to take place.
I can't disagree with you about that. I'm not looking for an exemption from review.
I appreciate that.
I'm just wondering whether it might be, I thought this would be resolvable today. And I guess my concern is that we need to have more discussion with the Bureau. So after a little bit more conversation here, I'd like to consider tabling this for today. Go ahead, Representative Brooks.
I saw Superintendent Chapa put his hand up. I'd like to hear what he had to say first.
That is fine. Superintendent, please go ahead.
Thank you, Representative. Relative to the external review, we have a suggestion. If you take out remove the language as determined by a provider, we think that would resolve not the mandate question, but the external review question. In other words, the provider wouldn't determine it. It'd be the normal process that would determine the external review.
Okay.
Okay. Yeah, I was, is it okay to go, Chair Tepler?
Yes, I don't see any other hands at the moment, though I think Representative Evans wanted to say something.
Sure. No, I was just going to emphasize, I do have a lot of interest in pursuing this bill. I think it's important that we make a statement as a community of our support for parity. So that's just my my take on this. I know our community has been affected a lot, and it'd be good to show support, right, in my mind, to help clarify parity.
Thank you, Representative Brooks. Anyone else on the committee have any comments, or does someone want to make a motion?
I just want to make the comment that obviously if this bill is going to need a mandate review, then we would have to head in that direction. However, if it takes up to 8 weeks to get our mandate review, then it's very unlikely, if at all possible, that we will be able to vote on this bill this year, which means I just want to make sure I'm understanding this correctly, which means effectively it will die at the end of this session if it's not voted through, or would it actually be able to carry over to a new legislature?
I think if it's undergoing mandate review, it's my understanding that the BOI comes back to this committee in whatever session there is.
Okay.
I believe that's correct. Superintendent, not if I'm not being stupid here, but that they bring it back to this committee when the review is done. And if we're not in session, it will wait till the next session. Is that correct? I think he just said, I believe so.
Yeah, that's correct. I mean, I think if you wanted to preserve the committee's authority to put in a bill or to maintain the authority to submit legislation in response to the Bureau's review and evaluation, you could amend the bill to sort of require the Bureau to do the study and report back to this committee next session and give the committee authority. So essentially you'd be, you could amend the bill that way to preserve authority to submit legislation in response to the review next time. That has been something the committee has done in the past when they run up against a mandate review in a second session, when there isn't any ability to sort of easily carry a proposal forward to the next session.
My preference would be, as the sponsor, to work with the Bureau to try to create a situation where this isn't a mandate, where it is simply a definition of parity for children's mental health care. And that's my preference, but in part because there is a crisis in children's mental health care, in mental health care in general, but particularly in children's mental health care. And I'd like to get something done to move things forward. So Representative Morris, go ahead.
Yes, thank you, Madam Chair. And I would agree with you on wanting to have the mental health parity and certainly wanting to have things covered that would be evidence-based. I think the other thing we would want to absolutely consider is how often this would be updated. So as I'm not as well versed in this as others, I'll admit, but there seems to be some comments submitted around the idea that if a new practice comes into play, figuring out a way that there's a way to have notice to the insurance company so we don't get to the Bureau about things not getting covered. So at least there's some level of predictability that things don't people don't end up having their insurance denied, their claim denied because it's a new practice, and the insurance company not realizing that the practice is new, so that there's some predictability around that. Is what I would just ask, that we make sure that we take that into consideration as well.
I'm willing to take that into consideration. I do think that the idea of evidence-based means that something would be vetted through an academic and scientific process, which means that I would hope our insurance companies are following the literature and looking at the peer-reviewed literature, so that I don't think if it makes it to one of those lists, I don't think it will be a particularly new practice.
Right. Yes, I just thought I'd bring up that concern. Just think, the biggest concern obviously is we don't want people having their claim denied wrongly, and making sure that everything is noticed properly.
Gotcha. Representative Evans.
Thank you, Madam Chair. Just to be clear, the insurance companies already have the opportunity, if they feel that something may or may not be medically necessary, they can request the patient's records or portions of the record that pertains to that particular issue. And they can make a review based on that. So they're not cut out of the loop. I don't see that this, in that first paragraph, that this is anything that is not already happening. I don't think we should continue to wait around on this.
I think we can pull out by a provider and work on some of the language, Representative Evans, and I'm hoping that we can do it by next week sometime, as opposed to waiting to the next session.
Yeah.
Thank you. Representative Brooks?
Yes, I'd agree. I'd really like to see something, if possible, and I'd make a motion to table.
Okay, it's been moved to table this bill. We don't discuss that. I think that Representative Arford is seconding. It's been moved and seconded, and because procedural, again, if everyone just puts their hand in the box. Okay, Poppy, are you voting for? Yeah, okay. It's unanimous of those present and voting to table this bill. And, you know, I hate to do that at this point in the session, but we've been moving along pretty well. I will close the work session on LD 1910 and open a work session on our final bill of the day, which is LD 1822. And I'll turn to Colleen to present the information on this bill.
This is 1822. This is another bill that we have not yet had a work session on, although we had the public hearing on this early in January, I think. But we postponed the first work session to accommodate the sponsor. So as drafted, LD 1822 prohibits insurance carriers from offering health plans in Maine that provide or cover any benefits with respect to behavioral health services from applying a copayment, deductible, coinsurance, or other cost sharing requirement to those behavioral health services. You have received some additional testimony and information about this bill that's been uploaded to the electronic LD file, including, I think, some additional information from the sponsor, Representative Morales, was sent to you this morning. There are some requirements in current law that were enacted as part of legislation considered in the last session, last legislature, related to cost sharing for primary care visits, but also for behavioral health care visits. So as part of that enactment of a broader law, individual and group health plans with effective dates on or after January 1 of 2021 are required to provide coverage without cost sharing for the first behavioral health care visit in each plan year. And then health plans also may not apply deductibles or coinsurance to the second and or third behavioral health office visits in a plan year. And then also further requires that any copays for those office visits count toward a person's deductible. There is a provision in the statute that says that this particular provision doesn't apply to plans offered for use with health savings accounts. So I wanted to make you aware of those provisions that are in current law. What LD 1822 would do is go much broader than that and prohibit cost sharing for all behavioral health services visits by health plans. You might also recall that we had a bill that we considered last session that was sponsored by Representative Arford, LD 1531. Under that proposal, health insurance carriers would be required to provide coverage without cost sharing for up to 12 behavioral health office visits for persons under 21 years of age in individual and group health plans. The committee voted not to pass on that bill, but sent a letter to the Bureau of Insurance asking them to consider proposed changes to cost sharing for behavioral health visits as part of their clear choice design rulemaking process. We had asked the Bureau to respond to us by letter this month, and we haven't yet got a response, but I think the Bureau is prepared to give us an update on the clear choice design rulemaking process today. A number of concerns were raised about this proposal and what its impact would have, what the impact would be on premiums and actuarial value requirements. Some of those concerns were expressed not only by carriers and employers, but also by the Bureau of Insurance. The question of availability and the impact on health savings account plans was also raised in testimony by the Maine Bankers Association and other employers that currently provide these types of plans. They raised concerns that the bill would negatively affect their compliance with federal rules. So if the committee moves forward, it was suggested that you consider amending the bill to make it clear that it doesn't apply to the extent that the requirements would make a high deductible health plan ineligible for a health savings account. And as I mentioned, the specific requirements that waive cost sharing for the first behavioral health visit, and make some other changes under the current law. There is an exemption currently, or an exception, for those high deductible plans. So that would be consistent with the approach that the legislature and the committee has taken with regard to this issue. And then also there were some concerns that the bill as drafted conflicts with requirements for parity. And we've just been talking about what parity means under the federal law. Does the bill go beyond parity in requiring no cost sharing? Because as we've talked about, the concept of parity essentially is that terms and conditions of a health plan would treat physical illness and mental illness the same and wouldn't have separate, treat them separately. And so this, because cost sharing is currently allowed for treatment of physical services, or the provision of health services for those types of conditions, that this bill might go beyond what's required under the concept of parity. And then you might recall as well that the sponsor indicated that similar legislation has been enacted in New Mexico, and the committee had asked for the Bureau of Insurance to see if they could get some information about the experience in New Mexico. It does, that proposal, as I understand it, does have sort of a sunset so that it would eliminate cost sharing until January 1 of 2027 and require some reporting back to the legislature about the effects of eliminating cost sharing with regard to costs. So I'm happy to stop there. I think the folks from the Bureau are still on your panel, so we didn't move them back yet. So if you have further questions for them, they're here, and I'm happy to answer any questions as well.
I turned off my video for a sec, but I'm back. I've been here the whole time. And I just, I am wondering if the Bureau wants to answer any questions in regard to the New Mexico experience, if anyone wants to ask further questions about that. It's my understanding, Mr. Yardley, that the New Mexico law depended on funding from a provider's tax similar to the 4% federal tax that used to be in place. Is that your understanding, or Superintendent? I'm sorry, I saw Mr. Yardley before I saw the Superintendent.
So thank you, Representative Tepler. I can't answer the question, but I'll see if I can, unless Superintendent can, I'll see if we can get an answer for you. I can tell you that New Mexico told us that because of the actuarial value requirements, they lost most of the bronze plans in the individual market, down from 5 to 1 in 2022, and lost some low-cost silver and gold plans as well. There were no rate increases, but this is only the New Mexico experiment's only 1 year old. It's not even 1 year old. So I think that there's not enough information to make any reliable judgments on.
After conversations with the sponsor and with the Democratic caucus on this bill, I think most of us are uncomfortable with moving to a full elimination of cost sharing for mental health. We're more interested in hammering on the issue of parity at this point. And so one of the ideas that came across to us was requiring parity for co-pays for behavioral health visits with primary care visits. I'm curious if the Bureau has any thoughts about that.
If I may, Representative, I'd like to take that back. We haven't considered that. Off the top of my head, I really don't have any substantive comments to make, but I did want to point out, we're doing market conduct exams of not only Anthem, we're going to do every insurer, health insurer with over, I think it's 1,000 lives, specifically on mental health parity. Where it's a market conduct exam schedule. So that, unfortunately, it'll take time to get done, but that'll be some information to for the legislature in the future on the carries compliance with mental health parity.
It's my understanding that some of the plans, the Clear Choice plans, already have that parity built into them, that are equal co-pays for behavioral health and primary care.
I was going to suggest bringing Marty Hooper in, who's leading the Clear Choice effort, who answer that question.
I'm bringing Marty over now.
Thank you, Superintendent. And thank you, Colleen.
Good afternoon. It's Marty Hooper, the Life and Health Actuary at the Bureau of Insurance. And yes, I think to answer the question, we did categorize the behavioral health services and primary care with the same deductible for the Clear Choice plans. There are different copays for specialists. So if there were a case where I just caution, you know, if there was a specialist that the person was going to see, those services could have a higher copay.
Yeah, because you said the deductible, but do you mean the copay? So is the copay the same for behavioral health, standard behavioral health visits, as opposed to with a psychiatrist or someone with a more advanced kind of specialty? The same as primary care in the new Clear Choice plan?
Yes, correct. The copay is the same. And all of the Clear Choice plans, except for the catastrophic and the HSA plans, that coverage is before the deductible.
Ah, okay. So do you see any problem with us putting that in statute for the foreseeable future, I guess would be my comment.
So the difference would be that would then apply to large group plans, because right now Clear Choice is just individual plans, and for next year we anticipate it for small group plans as well. So yeah, if you were to put that requirement into statute, I would expect that large group plans would then be pulled into that requirement.
Fully insured large group plans, I assume.
Exactly.
Okay, thoughts, comments from the committee? Yes, Representative Arford.
I support this idea, and I'm just curious as to, it was in our discussion during our caucus, it seemed that the majority, or potentially at least a good number of the plans that we currently regulate on the exchange, small group and the larger groups, like our main state employee plan, do currently offer the parity between copays for primary care and outpatient behavioral health. Is that correct? Or is there, I'm just curious, is there still a large section of that market that is not requiring that?
Who are you asking that question of?
I guess Marty.
Yeah, I don't know if anyone is more familiar with the state employee plan. I'm off the top of my head, I'm not sure how their co-pays work.
It's my understanding that we have parity in the state employee health plan. But I guess the question is, do you know if there's a segment of the market that we regulate that doesn't have that copay parity?
I'm not sure without checking. Yeah.
Well, thank you so much. So I think at this point, I'm in concurrence with the chair that regardless, even if we have it today, that's no guarantee we'll have it forever. So it does make sense to put this into statute.
And the other thing that I was considering as a way to move forward in parity with this bill is, Colleen, can you share with us the new federal model bill on parity, which I think was Section A? Can you screen share that with us?
And you were talking about the Kennedy Forum proposal that I had shared with you earlier?
Yes.
Yeah, okay.
So, my understanding was it was yes, models from the Kennedy Forum, but supported by the federal government.
Well, I don't know about if it's supported by the federal government, but it reflects, it's a model bill related to implementing and enforcing the federal parity law. And I'm not sure which section you're talking about, so I can scroll through it, but it talks about requirements for insurers providing coverage to submit annual reports to the Bureau of Insurance about their mental health and substance use disorder benefits, sort of their medical necessity criteria, an analysis of some of their non-quantitative treatment limitations, things like prior authorization, utilization review, credentialing, the results of that analysis to sort of demonstrate their compliance. Is that the one you were talking about?
That is the one I was talking about.
And so this is a model that's been developed by the Kennedy Forum, which advocates for sort of mental health issues, and has been developed and introduced in a number of states. I think there's 10 states that may have adopted this legislation. There are 10 states, which are highlighted here, that have enacted legislation that's based on this model.
So this, I believe, goes further than our current parity law. And I just would like to put it out there that this is something we might want to consider adopting to really put our finger on the scale of parity, and that we can use 1822 as a vehicle to do that. And I'm putting that out there today as a thought. I'm just wondering if anyone else wants to weigh in on parity issues that I know are very important to my caucus. And just waiting to hear what other folks in the committee have to say. Representative Morris.
Thank you, Madam Chair. I mean, we would have to see the details of any proposal as it relates. I mean, I'm not sure that it's entirely apples and oranges with physical and mental health. So I'd have to really kind of see the details and dig in a little bit before I could say whether, you know, I and I'm only speaking for myself, could support it and see how it, you know, would impact people's insurance rates and all of that before I could say that yes, we would be okay with it or no, we wouldn't. I mean, there's a lot to consider there other than just the rates too. That's one consideration. I understand that obviously, covering it saves in other ways. I do understand that, but so I guess that's my roundabout way of saying we'd have to see.
Can't disagree with you there. I think we need to digest it a little further also. It just seemed like these were two things we could put together that we could do potentially to further mental health parity in Maine. And I am going to ask the superintendent if he has any familiarity with this parity model.
I would just say there was legislation introduced on this issue in the end of the 129th legislature that came in very late to the HCIFS committee, and you did not act upon it at that time. It was a lot more specific about some of the reporting that would be required by health insurers about demonstrating compliance with parity. And I think the model that I just shared with you, I think has been pared down somewhat from what was proposed initially. So that was LD 1694 or LD 1654. I cannot remember the LD number off the top of my head from the end of the 129th legislature, but that's sort of the similar concept is what's being to that bill is what I think is laid out in the Kennedy Forum model, which is sort of requiring annual reporting by insurers to sort of demonstrate compliance and requiring them to do some analyses of their compliance with the parity laws. The earlier this session, we shared a federal report that was just issued at the federal level about stepped up sort of compliance and enforcement efforts by the Department of Labor, the Treasury, and other federal agencies related to review and of compliance by federally regulated plans, self-insured plans, and other employer plans on parity.
Thank you, Ms. McCarthy-Reed. And does anyone on the committee have further questions for the superintendent or Mr. Yardley? Seeing none, perhaps we should just send them back to the attendee space. I'm curious, just looking around the committee, does anyone have any comments or thoughts about the idea of putting in statute the copay parity between behavioral health and primary care? Representative Melorano.
Thank you, Madam Chair. So to answer your immediate question, it would be yes, I would be interested in that. What I will say, I wouldn't vote for the bill as originally drafted. I don't know how comfortable I would be completely eliminating cost sharing for one particular area, especially keeping in mind that as I understand it, cancer and heart disease are still our #1 killers in Maine. And so the thought comes to mind, well, if we do remove all cost sharing from one particular set of conditions, does it then decrease coverage for, other sets of conditions that may be just as problematic? But I have not reviewed that model bill about the model about parity yet, so I would need more time for that. But I would support an equivalent copay for behavioral health that we pay for primary care. I would support that.
Do people on the committee feel we should table this bill today? Think about both of those pieces that I sort of put out there to amend this bill, one being that copay parity issue and the other being the model parity bill adapted to Maine law. And think about it, and I think we'll ask Colleen to get together with the Bureau and think about how that compares to our current parity law and what kinds of things we would have to do to make it conform to Maine law, so that the next time we work this bill, we can talk more specifically about that. Does that sit well with everybody? I see Mark Blyer nodding. Yes. Yes. Okay, great. So I would entertain a motion to table.
I will make a motion to table this bill.
Okay, thank you, Representative Arford. And is that a second, Representative Melorano? Okay, so Representative Melorano seconded and Representative Arford made the motion. All those in favor of tabling, put your hand in your box, please. That's a finger. Okay, Representative Evans is confusing me. Okay, he's with us. All right. And Representative Quint, you had your hand up too, didn't you? Yes. Okay, good. All right, so we're going to table this for further work. It's kind of a complicated set of ideas that I put out there, and I think it will take some work to get us there before the end, but hopefully we will. Thank you. And that, with that, I'll close the hearing on the work session on LD 1822 and ask if Ms. McCarthy-Reed has any announcements or any member of the committee has any further.
I don't have anything further. I didn't have any language reviews ready. So what I will do in response to your discussion on LD 1910 and LD 1822 is to try to go back to the drawing board and come up with some proposed language for you to hopefully have a chance to review before the next work session on these bills, which I think might be Tuesday. Well, I don't know if these bills will be Tuesday, but most of the rest of the bills that we have not yet finally voted on, the idea and the plan is to take them up again Tuesday to see where you are and then kind of go from there.
Great. I think, Colleen, to be fair to you, we should think about maybe doing the work session on these at the very minimum on Thursday. And unless somebody has an objection to this, I'm going to suggest that at least these two, which require a fair amount of work for Colleen, move to Thursday. Is that okay with everybody? Yeah, I'm seeing heads nodding. All right, well, thanks everybody for your good work today, and we will wish you a good weekend and see you next week.
Thank you.
Bye.
Bye, Edna. Thank you.
Representative Morris, you want to sign off?